Committee Room 30. Sound.
Okay, so members, just like to remind you that we are now being broadcast online and throughout Parliament buildings. So welcome to those of you who are watching us and certainly those who are in the public gallery today. If you can ensure your phones are muted, and just to remind you that no photography or recording is allowed in the meeting. So I'd just like to start by thanking Connie Egan, who has left us as Deputy Chair. She's moved on to the Justice Committee, and welcome my colleague Stuart Dixon, who is taking over as Deputy Chair. So you're very welcome.
Thank you.
Stuart, and I believe you met with the clerk and his team this week, and
I did.
Good stuff. Okay, well, thank you for joining us. Okay, so members, if you're content, we're going to move on with the agenda. So Claire Sugden is just finishing off a Women's Caucus meeting at lunchtime there, so she's not apologised, but she said she will be slightly late. Is that? Sorry, and Harry Harvey's also previously recorded his apologies. So, any declarations of interest, members? Okay, no. Okay. So, in terms of chairperson's business, members, page 6 of your pack, you'll see the email from the DALO to the clerk regarding the invitation from the First Minister to meet the chair, and you'll also find the minutes of the meeting of the chair's meeting with the First Minister. If anybody got any comments to make, go ahead, Timothy.
Rand, you want to go first?
No, you got your hand up first. It's fine. Go
That's
ahead.
all right. I suppose just want to start off, Chair. My attention was drawn to the newsletter article earlier on by David Thompson, in that he sought notes from the meeting through FOI that have been refused by the Executive Office. I'm very curious to see what's in them written notes. I think it'd be fit.
Is this the private office or is this the
private office?
Okay, well, have you written to the private office and asked them?
Not yet, but I think because it relates to this committee, I would like to make a proposal that this committee requests them, because they relate to a meeting that was held, a private meeting that was held with a witness, relating to this committee. So I'd like to make that proposal today.
I have no problem because
we asked for them, because it's the opportunity to validate what you have said. There's a number of points I would like to make if possible.
Can you come and take them under any other business, because we have our panel in?
That's grand, as long as we come
Okay.
back to it, but I would like the proposals put before the committee
Okay,
here
well,
today.
we'll come back to the proposal. Okay, so in terms of... I just wanted to raise the issue. We had our committee motion yesterday into the review of the recent racist incident, and asking the First Minister and Deputy First Minister to bring forward a rapid review. I have to say, I thought the contributions from all the members, although maybe slightly different angles, I thought that they were really valuable. But I have to say, I was really disappointed that despite the motion passing, the committee motion passing, they have not taken on to conduct this rapid review, even though the Victims Commissioner designate has asked for it. So it's not just this committee. I just think that it falls well short of what we really need in terms of supporting those people who have given evidence to this committee, also those who we have all met privately and corresponded with, and who are hoping and seeking assurance that we will not have a repeat of this in the future. Anybody got any comments to make? No. Okay, go ahead, Carol. Thank you. Tom's just messaging now, Carol, sorry, just a second.
Yeah, Paula, I think we should write. Following on from the debate yesterday, I thought the response was disappointing.
Yep.
So given that the Interim Victims Commissioner had asked for it.
Oh, we lost you again there, Carol, sorry. Okay, but we have a proposal in terms of...
Sorry, Paula, just think we should write off. That's a proposal.
Okay. Here, Sinead, I see you nodding. Are you in agreement? Yeah, okay. Any country views or any other...
Right off, just clarify.
So the wording of the motion was effectively to ask for a rapid review to look at what happened, who was involved, what measures are going to be put in place, etc. And we didn't get that assurance yesterday in terms of the response from the Deputy First Minister. So there was talk of engaging and meeting with people and stuff, but I think that what we're looking for goes way further than just those people who were at the brunt end of it, but also in terms of looking at engaging with the police and other agencies who provided support or assistance, etc. at the time.
Well, I thought there was that agreement to the review, but certainly we'd need to follow up in writing anyway, so obviously we can do that.
Okay.
That's to write to the First and Deputy First Minister.
Yes, and ask them for thank them for responding, obviously, to the committee motion, but also to raise concerns that they didn't give a firm commitment for the rapid review and to see what can be taken forward. Okay, so just to move on. So members, we had a meeting this morning. The clerk and I met with HIA Victims and Survivors Group on the subject of memorials. They expressed concern that they have not been engaged with by the department. And you'll recall when the Deputy First Minister were here, they said that they would be engaging with the groups for the summer. The survivors groups this morning also said that they have written to the Executive Office 3 times since the First Deputy First Minister have come into post asking for a meeting and have not got one yet. So you will know that next week in the Forward Work Programme we have Paul Sweeney to talk about the contributions from the religious orders, but we also have a departmental official here talking about HIA. So I've asked the representatives from the groups to email you all individually to sort of outline the concerns and the issues that they would like raised. So is there anything else to add from that? Oh yes.
Just to see agreement for the sharing correspondence from the Department of the Arts Council.
Okay, so whenever we had the panel with the HIA Victims and Survivors earlier this year, they asked us to raise some points on their behalf. So we wrote to the Executive Office and we also wrote to the Arts Council NI, and so this morning in the meeting we were saying that the responses came back, there was some information with it, so I'm just asking your agreement that we can share those responses with, it would be Rosetta Trust, Survivors Together, Survivors Northwest, and then possibly with Savia. So are people in agreement that we share those?
Agreed.
Okay, thank you. Just moving on quickly then, draft minutes are in your pack. People content that they're a true reflection?
Agreed.
Okay, we'll just go ahead and sign them. And then in terms of the matters arising, there is a list of correspondence and briefing papers received from the department in your table pack. And then I would just advise you that at last week's meeting the committee agreed for the committee staff to collate information on the timeliness of papers to the committee since the committee was formed. I just want to seek your agreement to forward this list to the department to seek updates on all outstanding correspondence and to ask for the reasons for the lateness of the papers and what steps the department intends to take to ensure that it is in compliance with agreed protocols in the future. Is that okay? Are we in agreement? Go ahead.
I had thought we were going to talk about the minute of your meeting with the First Minister
So
under
we're going
matters
to take
arising.
that under any other
Okay.
business because it might take some time and we've got 3 panels today.
Okay, but just it came up. It was in the minutes of the last meeting. That's when the matter was raised. But okay, we'll leave it till then.
Okay, so moving on to item 6 then. So we've got the Independent Monitoring Authority for Citizens' Rights Agreement. So we're going to take oral evidence today. So members, on page 21 of your pack you'll find the clerk's brief, and on page 23 you'll find the IMA briefing paper. So I'm going to, all from the IMA, so I'm going to welcome Leo O'Reilly, Interim Chair, Miranda Biddell, Chief Executive, Rhys Davies, is that, General Counsel, and Helena Geitch, Acting Head of Inquiry. So thank you for coming today and thank you for prior correspondence. Can you just make your opening remarks? Thank you.
Thank you, Chair, and thank you again to you and your committee for giving us this opportunity just to talk briefly to you today about our work. As we set out in the letter to you of the 1st of November, the IMA was created as part of the EU withdrawal agreement between the UK and the European Union and was brought into statutory effect at the very end, 31st of December 2020. Our basic role is to monitor and promote the rights of EU citizens who have opted to remain in the UK after Brexit, and those rights are set out in considerable detail as part of the EU withdrawal agreement, part 2 of that agreement. Our remit extends to public bodies everywhere in the UK, so that includes government departments, local authorities, the devolved administrations, and any other body that's carrying out what would be defined as a public function. As I said, the citizens' rights in the agreements are set out in Part 2 of the agreements. They're quite widespread. They include residency, which includes the right to move between the UK and the rest of the EU freely, the right to work, the right to mutual recognition of professional qualifications, coordination of social security, equal treatment, non-discrimination, respect of housing, education, healthcare, etc. We've been operating now for almost 3.5, coming on 4 years. So we just wanted today to highlight to you what we have been doing, and in particular then the issues that particularly we believe affect Northern Ireland. A major factor for us and consideration for us since we were set up was the operation of the EU settlement scheme. This is a scheme managed by the Home Office, under which citizens who wish to remain in the UK are registered in that capacity, and they can either have settled status if they've resided here in the UK for at least 5 years, or they can have pre-settled status, which then should become settled status after they complete that residency period. That scheme now covers over 6 million people in the UK. Most of those the scheme has worked satisfactorily for them, and they have registered as having settled status. However, there are continuing difficulties with that scheme. There are delays, and we currently have an inquiry running into the delays affecting that scheme. We also know that citizens have difficulty sometimes registering their rights, and there are also a continuing number of new applications. We estimate from the Home Office tell us that they're receiving between 5,000 and 11,000 new applications per month to that scheme. So it's still a very live issue, and as I said there, it affects 6 million people, which I think is one in 10 of the UK population. So there are very large numbers involved here, and we have a role in terms of ensuring that their rights in terms of residency are properly protected. A second high-level area for us at the moment is the whole issue of borders, and by borders I mean here the entry and exit to the UK at both through ports and airports. That has become there are plans, as you probably have all seen in the media, to move to electronic travel authorisation next year, where effectively your digital status will determine your right to enter and leave the UK. There is an existing scheme for EU citizens who have settled status called View and Approve. So we have already had experience of the operation of an electronic system, as it were, and again, that causes difficulties and certainly concerns for EU citizens in terms of being able to prove their status when they're entering and leaving the UK, and there have been difficulties in that area as well. Briefly, other areas, because my colleagues will come on to it, include issues around access to benefits and homelessness support, which is a live issue for us at the moment. We're engaging with DWP on that and the local Department for Communities. And a final review we carried out at the beginning, and it was a major review which was actually looked after children in care across the UK, because part of the agreement with the EU places quite strict deadlines on when people should apply for their status, and obviously we were concerned that children who are in care or who are leaving care, that aspect might be overlooked for those of them who should be applying for status under the settlement scheme. So, for example, in Northern Ireland, there are 280 children in those circumstances, and many thousands across the UK. So we've been conducting a major exercise to ensure that local authorities and those responsible for social services have taken proper account and are taking action to ensure that those children are properly registered under the EU settlement scheme. Mm-hmm. There are many other areas, but rather than take up too much of your time, I'll hand over to Miranda, who give you some information particularly specific to Northern Ireland. Thanks, Miranda.
Thank you very much for having us. One of the questions we're always asked when we come to a devolved administration is, well, what about us? So I wanted to give you some highlights of the data specifically for Northern Ireland. So since 2018, when the EUSS scheme was opened, there's been 137,515 applications in Northern Ireland, which is 2% of all applications across the UK. So quite a sizable group. Approximately 18% of those applications are for people that are 18 years and younger. 80% of the applications, the majority that we see across, would be of working age, so 18 years to 64. And we're seeing 2% of those applications are retirees, 65 years and above. So that's the kind of rough figure that we have seen so far in the EUSS. Now, what we are seeing, though, and Leo mentioned around, they were people that have already applied for the scheme, and you'll be aware that there was a cut-off point for applications for the EUSS. What we are seeing is an increasing number of ongoing applications. So Leo talked about that national figure of additional applications that are coming in. Now, according to the Home Office data, there's been a 4.7% increase in applications from January to June of this year. So that means approximately 1,000 new applications a month. Now, I would say the slight caveat on that, that's applications, not people. And some people, those applications will be repeat applications. So if they've applied once, they might apply again if there's been a refusal or they need a different status. So it's not necessarily that you've got 1,000 new people every month, but it gives you that scale that this is going to be going on for quite a while. Some good news, in the same period of January to June last year, so of those applications, there was around 6,319 that were concluded. And of those, around half got settled status. So that's citizens that are presenting their evidence, and there's been an agreement that they'll have settled status and they can execute their rights. Around 6% have had pre-settled status, so that's usually when further evidence is needed before you can move to the settled status. Now, when you compare that with Northern Ireland, with what we're seeing elsewhere, that's a slightly better proportion of those that get a positive outcome for settled status rather than needing to provide additional evidence. The not so great story is that nearly half of those that apply, the application doesn't continue. Now, 22% of those is because they receive a refusal. So you present the evidence, it's deemed not to be satisfactory to meet the scheme, and you're refused. You can apply again, which is why you get that 1,000 a month, but 22% are refused. Now, 31% are either withdrawn, void or invalid. And it's quite difficult to dig underneath about what some of the themes are, but it does mean around 50% of the applications are kind of stayed and they're not concluded. So some of the bits that I just wanted to highlight for you of what that might mean. So we've talked around future generations and what this means. So we've talked about under 18s. It's quite a high number of applications. Now for that group, just under 1,500 have been refused, but 7,287 have been given pre-settled, so they haven't quite got over the line. So that means you've kind of got a queue of 9,000 under 18s that haven't yet got their status settled. So that causes some challenges for that generation about what that will mean for the future, but also accessing education, health, all of those services for young people, that can be quite difficult. In terms of applications that are made, 25%, so a quarter of the applications that are made for EUSS in Northern Ireland are from Polish nationals, and then the groups that fall underneath would be Romania, Bulgaria, Lithuania and Portugal. So quite a high proportion from Eastern Europe that would be applying. I'm sure that's no surprise to the committee. In note of refusals, what I would point out is that there's a slightly higher refusal rate. And when I look at the data from the last 6 months, the refusal rate is proportionally higher in Northern Ireland than other of nations across the UK. So in the last 6 months, the refusal rate in England was around 8%. In Scotland, it was around 4%. In Wales, it was around 7%. And in Northern Ireland, it was 13%. So quite high. Now, some of the things that are fed back to us is why might that be the case, and it's quite difficult to dig underneath the data. Some of that is being able to provide the right evidence at the right time. So being really clear, you have to go back 5 years in terms of your residence, your work, your benefits, national insurance contributions. So some of that can be quite hard to collate that data. Increasingly, you need a digital footprint. So some of the information is pulled down from other government systems. So if I am living in a family and it's my husband's name that's on the tenancy and my name's not on the tenancy and I'm a carer of preschool children, I've got a very minimal footprint to evidence my status. So that can come into play. The other bit that I would highlight is sometimes you need some help in filling those forms out. I don't know about you, but whether it's digital or hard copy, sometimes trying to work out what evidence you need in what sequence can be quite difficult. And what we are seeing as we move further along, those that were fairly easy, if you've always worked, you've lived in the same place, it's likely that you've got settled status. And even if you're in pre-settled, the new automated process that the Home Office is bringing in is likely to scoop you up. Because you'll be able to see in your process. But if you have vulnerabilities, or if it's slightly more complex, or you've got gaps missing, or there's been absences, or if you were impacted with COVID, then that can be quite difficult to provide that evidence. And what we see elsewhere is that you can reduce the refusal rate if you've got really good advice. So if there's funded advice for citizens that can make sure they get the application in the first time, it's helpful for the citizens, but it's also helpful for all of us because it means there aren't multiple applications. So I guess it would come back to one of my asks later, making sure that there's some support is really helpful. You've got some really good agencies, and we've met some of them in Northern Ireland. This morning I've been at Advice NI. I've been hearing about their projects that they're doing to improve access to e-visas and digital support, and some of the advice that they give citizens. But I think it's clear from some of the data that we've looked at that there are some challenges in your communities about how they get that support and advice.
Okay, anyone else want to contribute at this stage? No? Okay, well.
I think it might be, if it's helpful to the committee, I can talk a little briefly around how we go about monitoring. So Miranda's talked very briefly around the statistics and what does that kind of mean, and kind of what that could suggest. Miranda's also talked about how we would engage with some of the sector in terms of how that monitoring works. But I think what we also are keen to do is to tap into the rich network of other regulators that are across the UK. I think we are very new, as Leo mentioned. We don't want to reinvent the wheel. There are other organisations across the UK, whether that be in the third sector or in the public sector, who scrutinise what is happening amongst public authorities, whether they are doing what they should be doing. And I think, thinking specifically around our role, there are ombudsmen who have responsibilities in relation to housing, in relation to health service, but also, like in Northern Ireland, there's the Housing Executive. There are bodies like the Northern Ireland Human Rights Commission, the Equality Commission Northern Ireland. They are all bodies which we look to work with and collaborate with for a few different reasons, depending on the institution. I think if you're thinking about the ombudsmen who are active in the housing sector, what they see in terms of housing is very important to us when it comes to looking at the support available for the homeless. So we look to see where does our remit start, where do their remit start, where there is opportunity for collaboration, where there are opportunities for us to pass information to them, where they can pass information to us. And I think over the course of the time that we're here over in Belfast, we are making the most of that and maintaining and continuing relationships with organisations like the Northern Ireland Human Rights Commission and tapping into what they're seeing in particular around how the withdrawal agreement is to be applied, and just ensuring that we have as many different perspectives as we have to inform our work.
Okay, thank you. Do you want to say anything, Helena, before we move on?
Would you like us to talk a bit more about what we do, or would you just like to ask us some questions?
Well, obviously we'll be asking. Maybe we'll move to questions then, and then we'll try and find a way to bring it. So thank you very much, and thanks again for your report in advance. So I suppose we as a committee, we're all about sort of human rights and equality. It's one of our main focuses, and I'm just wondering, what evidence is there that there have been any infringements of rights of EU citizens in Northern Ireland in particular?
Absolutely, very happy to pick that up. So, as you might imagine, as part of our work, we sort of uncover all manner of issues and potential problems that we've investigated further. And what we've recognised is there's sort of broadly 3 thematic themes at the moment that we're looking further at. And they are the future generations, as Miranda has talked about, looking at access to support, and then travel for citizens living across the UK, but also here in Northern Ireland. So with regard to future generations, as we've already pointed out, a lot of our work has been about the front end, so about those applications to the EU settlement scheme, and ultimately making sure that people who are eligible under the agreements are able to demonstrate that they have access to those rights. So you'll be aware that we've conducted a COA inquiry, an inquiry into the issuance of certificates application, which is a part of the EUSS scheme, which makes sure that citizens can access their rights from the point of application. And as such, the IMA made various recommendations to the Home Office, which along the lines of suggesting that better and more informed data should be extracted in order to ensure that compliance can be demonstrated going forward, and also notes about the timeliness within which applications are being progressed. And then sort of more broadly, concerns have been raised regarding the ongoing rate of applications. So as Miranda alluded to, here in Northern Ireland, there are still in the region of 1,000 applications a month being made to the scheme. I think aside from the point that some of those will be duplicate applications, there will be genuine late applications within that batch. And there was new guidance that was issued at the start of this year which required such applications to demonstrate reasonable grounds. So in some ways this is a necessary but additional barrier for citizens who perhaps have lived here their whole life but want to continue to live here and to be able to exercise the rights they're entitled to. So that's an area that we're continuing to look at, particularly for citizens who may not have already applied, so citizens who have an indefinite leave to remain here anyway but need to make and formalise their residency status in order to continue enjoying those rights. We've also looked at the, as has been talked about, vulnerable groups. So looking at the status of citizens who are children and are under care of local authority. And we worked really proactively with all 5 health and social care trusts here in Northern Ireland. And we were able to confirm and be assured that there were appropriate measures in place to ensure that the rights of eligible children were being protected. And that wasn't the same case for across the UK, so it was that we were able to take lessons from that and to be able to develop guidance to be able to inform other parts of the UK to ensure that that was being properly delivered. We've also focused our attention on access to support, so ensuring equality with respect to that. And some of the issues that have been flagged and that we've subsequently looked at is around education support. So we worked here to ensure that clearer guidance was issued in respect of equal access to education in terms of financial support for people who have rights under the agreements. We also most recently looked at civil service job description and requirements. So again, we engaged with the executive to identify concerns we had in respect of that guidance, which had the potential to exclude eligible citizens, so citizens with pre-settled status, so not quite that permanent residence to reside, but also those with a pending application who may be caught in the backlog of applications that currently sit with the Home Office. And then just finally, with regard to healthcare charges, a piece of work we did, I think it was about 2 years ago now, again, just looking at the wording around that to ensure that it fairly and accurately described the requirements for citizens to be eligible for free healthcare, but also to seek assurance that nobody had been unfairly charged, which we were really happy to confirm. And then just finally, some of the concerns that our stakeholders are telling us and that we're continuing to look at is about travelling. So you'll be aware that there's an ever increasing movement towards digitisation of our borders. We know that there's going to be the introduction of the electronic authorisation requirement, and some of the concern is sort of the impact this might have on, yes, citizens with status, so with pre-settled and settled status, but also those with a pending application, and there's concern around how that freedom to travel and re-enter the UK, once that's introduced, will be able to continue in light of some of the challenges we see with the digital system more generally.
Okay, thank you. Just quickly then, so the Home Office recommendations, were they taken on board?
So the Home Office, we made several recommendations. Yes. It was 5 in total. The Home Office accepted that they needed to extract more meaningful data, and that's sort of representative of our findings more generally in the work that we do. Sort of we feel, and that we are told frequently, that actually the data that we're able to work with it's difficult to interpret and really understand what's going on for citizens on the ground. So that's something across all of our work really that we're finding and continuing to recommend in order to inform the work that we're doing.
Okay, well, two quick questions from me and then I'll hand over to the Deputy Chair. We're, as a committee, conducting an inquiry into gaps in equality legislation, so we're very mindful of marginalised groups, for example, and I know you talked there about only 2% of the applications in Northern Ireland are for people over 65, but there is that digital divide in many ways. I'm just wondering how you are tackling that. And the second one is, maybe it's within your remit, but I have a live constituency case around this, and it's around the mutual recognition of professional qualifications, especially in health, and if there's anything you can speak to in that space, I appreciate it. Thank you. So the first one was around digital barriers for, or again.
So I'm happy to take the second one, the MRPQ one.
Okay, shall I do the digital one then? Okay, so certainly like digital awareness, and it's not just older groups, but I think also our office is based in Wales, so we understand some of the geographical challenges of also having strong broadband connectivity to make sure you've got consistency as well as being digitally literate. I think it is a challenge, but I think there are some increasing approaches across public services. So the scheme that I was hearing about this morning with Advice NI, they've been going into care homes, for example. They're training up digital champions and training staff and providing equipment to help with that so that people can access accounts. And I think if you're connected to a public service, I think as public services we're more mindful and aware and thinking about supporting people to improve their digital savviness, if that's a word. I think the challenge is for those that aren't in touch with public services. So if you are in residential care, if you are actively accessing medical services or social care, you probably have more chance of somebody supporting you through that process. I think the challenge is for groups that don't necessarily engage or where there's a trust and confidence. So for some of the EUSS cohort that we have, you will have some populations that won't engage with mainstream public services through confidence, through trust, or they're cared for by their family rather than public service. So I think that's the element around equality and access that we need to look at. We had an interesting conversation at the Senate in terms of their future generations work with digital. And, the IMA's position is all government services are moving to a digital approach, but the commitment and the responsibility we all have of thinking about what that means in the future. So as we expand digital services, it's building in that support of what about the digitally excluded or those that aren't confident? Do you have a plan B? Do you have support to engage with them? So we're not seeing anything different in Northern Ireland than we're seeing elsewhere. I think that's something that we all have to consider.
Thank you. Do you want to respond to?
Yeah, on the qualifications, I think it is an area that is possibly an area that we've had less reason to deal with. It's not necessarily an issue that is raised with us consistently by stakeholders. I think we have done some work in relation to new legislation as different governments look at the future post-Brexit, developing new policies and how qualifications are to be recognised, in particular thinking about expanding kind of recognition to other parts of the world than compared to just the EU. In terms of the what that means for the individual then, if we're not seeing it much, it's not being reported much to us, it's probably not something that, one, there's a lot of support out there for. Possibly if you're engaging with a sector or a public authority that they haven't dealt with it before, there may be real problems there and people may struggle to know where to turn to. So I think we are continuously seeking to promote awareness of the IMA, and one of the benefits of that is that people can report things to us. So I think if it's a specifically constituency member that has an issue, then I think it would be they could report the matter to us, but also having a think about what other support services are available in Northern Ireland for them. I think the important thing is that the recognition needs to have taken place pre-end of 2020 for that to be kind of honoured, and that's where possibly it's more of a time-limited issue that rather than something that is...
I'll go back and look at it with fresh eyes. Thank you. Stuart, please. Thank you.
Thank you, Chair. Thank you, and thank you very much for a presentation. Obviously, coming new into this committee, and appreciate this is a steep learning curve in terms of the role that you have and what you're doing. I guess probably the key lesson out of this for me today is we should never have left the EU. But other than that, the reality is we are where we are, and you have a task to do, and I understand that. What maybe just sort of in that broad theme, not the theme of whether we should or shouldn't have left the EU, but in that broad theme of what lessons have been learned, or indeed have you any lessons that you could have learned from the Windrush scandal in terms of that, because that is a very much an ageing population of people, people who were either completely unaware of what they needed to do, or to this day remain very scared of what they have to do. So have there been any lessons learned from the Windrush circumstances?
Do you want to start?
I'll start briefly. Yes, we have looked at Windrush, obviously, and it's been raised not just by you, but it's been raised by members of Parliament over in Westminster as well, the background to this. In simple terms, the Windrush arose because a particular cohort of immigrants into the UK in the 1940s and 50s, if I can use the term, got lost in the system because it's a very large, very complex system, which meant that when the government began to take action in order to remove what they perceived to be illegal immigrants, some of these people got caught up in the system. The challenge we have is that they reckon that, from research done, that there are roughly 57,000 people affected under the Windrush scandal. As I mentioned at the beginning, we're dealing with a total cohort of 6 million people. So like 1% of that is 60,000, 10% is over 500,000. So the action we hope that by having the IMA is, first of all, you have the IMA, in other words, it's an organisation that's specifically focused on this large cohort of immigration, but also that it's an organisation that can liaise with public bodies, but it's something, you know, that there isn't a concern about out there, and it's been raised by others. Miranda?
Yeah, exactly. I mean, I think some of the key differences, as you said, we're here, so part of it was needing an independent body to monitor and oversee. There's been some significant learning in the Home Office in terms of their recording and reporting, some of the promotional work that they do, but also the funding to support groups. So in Windrush, there were no support groups to advise citizens, or limited if you look at the comparison. So there is more funding available of that. I think it's more of a live issue. So I think there have been some lessons, some of the risks have been mitigated. And in the scale of EUSS, you know, for nearly 9 million applications and 6 million have been done, there's some real positives in the scheme, and there's been some learning. I think some of the areas that we continue to be concerned about is there are a couple of groups. So those that are referred to as indefinite leave to remain. So post-Windrush, sort of people that came as I was born, you know, and have lived here for generations and have had the wet stamp or the biometric in terms of you can stay. That group are now having to apply for residency. So it's how good are we collectively of advising people they need to do that. But there's also what I refer to as a potential of the unknown category. So, and some of those are indefinite leave to remain. My home is in not far from Cambridge in England. And I had some citizens that came up to me and said, we've been here since the 70s. I had no idea this meant us. So there are still people that are coming forward of like, but I've always worked here. I've paid a mortgage. I've contributed. I've done all of this. Why on earth does that mean it's me? So I think, but there's at least that awareness and questions are being asked and people are collectively looking at, is there anybody else that we need to talk to and how can we improve that?
And is the scheme currently closed in that sense, in that everybody who wants to apply should have applied by now?
Tricky question.
So in terms of, there was a deadline specified by the UK government in accordance with the terms of the withdrawal agreement of 30th of June 2021, but there is then, I suppose that's the other difference with Windrush, is that there is a mechanism for late applicants, and that is indefinite. So there will always be the possibility for a late application.
Yes.
However,
there's a deadline, but there's not a deadline.
Well, there is a deadline, but then if you are applying late, then you need to give good reasons why you are late. I think Helena mentioned it earlier.
Is ignorance a good reason?
No.
And is there a right of appeal for that cohort of people who haven't been able to complete their application successfully? And it may be that there are gaps and the digital issues and all of that. Is there an appeal mechanism? Because you made reference to the fact that people apply again. Is that how you appeal, or is there an appeal mechanism?
So I think it depends at which point you're caught. So if you make an application and it's deemed invalid, so that is because possibly you are required to provide biometrics and you have not done that, or you are applied to submit the right documentation, you haven't done that, then there is no right to appeal at that front.
Is there an opportunity to go and get that information?
So yes.
So you can put a delay into you can say, okay, I wasn't aware of, or I didn't know how to get that biometric data. Yeah. You've now told me how to get it, or you've guided me, or you've pointed me to somebody who can provide that information.
So on the biometrics, there is a need to provide that within a certain period of time. You can make an appointment online. If you don't then make an appointment and turn up at the appointment, then your application rejected. Okay. Similarly, if you're late and you've not given good reasons why you are late, that is also rejected. Now, you could just review that decision, but there is the possibility for you to reapply and set out more fully the reasons why you believe that there are valid reasons to make late application.
Just sorry, briefly, Chair, two other questions. Are there any implications for people on this island who consider themselves to be Irish citizens, either living in Northern Ireland or in the Republic of Ireland, for this scheme, who don't have a previous other nationality within the EU?
So I'm happy to take that one. So in essence, anybody, any EU citizen, including Irish citizen, can apply to the EU settlement scheme. But evidently there are the common travel arrangements which coexist, which would kind of provide the same rights and more for an Irish citizen.
So the common travel area is essentially the short answer to that question.
So it coexists alongside that, and I think the Home Office guidance sets out quite clearly what somebody in that situation could do. So they may.
I probably would have lots more questions. We'll just one very brief final question. Has anybody been removed from the United Kingdom as a result of this? And could you give us a little explanation of why? And again, is there an appeal mechanism for that?
I mean, we can give some details, but it's difficult for us to respond to that because it would be the Home Office and Immigration Border Force that would make the decisions on the removal. And there is a separate body that would oversee that in terms of the Immigration Commissioner in the UK. But we can give a little bit of
types
of examples?
We're certainly very keen that anybody with pre-settled status is able to secure, as soon as they are eligible, the permanent residency rights, which is the same as settled status, whilst they're living in the UK, because whilst they're living with pre-settled status, they run the risk of sort of potentially unintentionally breaching or breaking the rules of the arrangement. So, for example, being out of the country for longer than they're allowed to be, in which case that could result in the status that they have acquired being removed from them, and then therefore no longer being eligible to reside in the UK. So I think that's sort of an area of focus for us, further to the JR that we successfully brought against the Home Office, which proved that citizens with a temporary right to reside automatically acquire that permanent residency. It's about looking at how that's going to be implemented effectively going forward, so that everybody who has that pre-settled status here can acquire that permanent, more secure level of status, so that they can enjoy their rights and reduce the risk and the fear of removal, as you just alluded to.
And if I may, just one very, very brief point, just to assure the Deputy Chair that there are appeal mechanisms for both refusals of an initial application and for any attempts to deport, any decision to deport. There are clear appeal mechanisms in place for both.
Okay. Thank you. Claire, please.
Thank you, Chair. It's interesting, and forgive me, I probably am quite limited in my knowledge of what you do, so some of my questions may be based around that. I suppose I'm quite interested in the vulnerable applicants, and particularly those under 18, and you talked to the support that's required to enable someone to fill in an application successfully. I suppose I want to understand who does that and how they're equipped and how they're trained and informed and knowledged. I have some casework experience of this where a young man, probably more from an asylum perspective rather, but I feel that there's overlap. Essentially the support that he was given was coming from social services, but realistically social services were not equipped to fill in his application correctly. And it was only when a community and voluntary sector partner got involved who had the legal expertise and knowledge that he eventually had leave to remain within the United Kingdom. Otherwise he was going to face a very grim removal from the UK. And I know you talked to your confidence around Northern Ireland having that expertise. In my experience, I would disagree with that. I think we don't have the legal expertise in those areas to fully support people in applying for settled status. And I suppose really then to follow on from that, does the Northern Ireland Executive, the region, do they have a responsibility to ensure that support and advice exists, whether it is through funding community and voluntary partners to provide that? I suppose, where does your monitoring then come into that in terms of what Northern Ireland is doing for its, I suppose, the people that want to stay here? Because, it does concern me that we have a refusal rate that's 13%, which is nearly double the other regions, and certainly from anecdotal, small sample experience, I would say that's why, that applications are not just being filled in correctly. So then that would give rise to me for equality of access issues. And so if you could talk to that, I would appreciate it.
Absolutely. I mean, that's why I was saying at the end of the day to why it's so important to have support services available, and to have the right support agencies available so that they're regulated and accredited. So, going back to the Windrush question, the Home Office have funded independent sector organisations to ensure that they can support citizens.
Does that come to Northern Ireland given the devolved status? So it's not necessarily up to our executive to give that money to the...
No, so
okay.
from central point, because it's a reserved matter,
okay, sure.
The Home Office fund some support agencies in Scotland, Northern Ireland and Wales.
Okay.
Is that sufficient? Does it meet the capacity? Certainly meeting some of your support agencies in the last couple of days, the indication is no, it's not. Yeah. So in terms of approved and regulated legal advisors that can specialise in the EUSS scheme, what's being fed to us, it doesn't feel as if there's sufficient capacity. And that's directly linked to funding. Now, what we do see in devolved nations is a difference. So there's that core funding from the Home Office to try and support those applications. Scotland and Wales' executive separately support and provide additional funds for immigration advice, not just for EUSS, but across the board. So I guess, is it on my wish list? You know, it can really help in terms of that cohesiveness and getting it right. And, you know, from a social rights point of view, if you look at the amount of citizens that are 18 to 65, they want to live and contribute to our economies and our communities. So any way that we can do to make that better is helpful. There's also some vulnerable citizens that have more complex cases and need some support, and having that professional advice can help either get the settled status or have a definitive answer, so you can then make life decisions about what's going to happen in future years.
Go ahead, yeah.
I suppose it's to pick up on the Deputy Chair's point around those living on the island of Ireland, and I suppose it's the Good Friday Agreement, as we all know. You have the right to either be British and Irish in Northern Ireland. However, from a jurisdictional perspective, that potentially plays out differently, because it's not just about having a travel document, it's not just about saying you have a particular identity, it's actually about the laws that pertain to the jurisdiction. Is there any issues in relation to EU settled status about the jurisdictional issue? And I'm not talking about people's right to be who they want to be, I'm talking about the law. Is there any issues that you've come across in respect of that?
I think I'm happy to take that one. I think in terms of the scheme, the EUSS scheme, which people apply to, there is the possibility for all EU citizens to apply for that, where if they have been a resident in the UK before the end of the transition period, the end of 2020. I think there is an additional category which may not necessarily fall within the withdrawal agreement, but falls within the scope of the EUSS scheme, which concerns the relevant people of Northern Ireland. So where you were born in Northern Ireland, whether you were Irish, British, or identify as both, but also to a parent who is one of those, then you can apply for settled status. So I think that was a later addition to the scheme that was recognising kind of the particular kind of characteristics in Northern Ireland, so to ensure that people could apply.
Okay, and is that in compliance with law, legislation? Because we've had a similar, I'm thinking of the Emma D'Souza case in particular, in relation to that. And I suppose what that revealed is that, you know, we have this international treaty in the form of the Good Friday Agreement. However, when it came to the implementation of that, the laws didn't necessarily, so yeah.
I think the distinction that Reece has really drawn out, but Irish citizens have obviously pre-existing rights under the Common Travel Area, and those continue in place. But as Reece said, if they wish to, they can apply to the settlement scheme. But then you've got an additional category of citizens who are people who are EU citizens who are not Irish but other nationalities living in, say, the south of Ireland,
Yes.
and then the question is their right to move across borders, and those issues that raise as well. And that works in both directions, because as I'm sure we've all seen sometimes, the southern government are also engaged in conducting checks on people moving across the border to check that they have a right to reside or to be in their jurisdiction. But it's fluid and it's ambiguous at times, the situation.
Thank you.
Okay, thank you. Timothy, please.
Thanks very much, Chair. Some people look at the protocol as mainly being regarding trade. From your evidence, you clearly don't. Could you sit out and explain how you see EU citizens' rights limited here in Northern Ireland? So I've heard a lot about red tape, and you've mentioned about future generations, access to support and travel, but day and daily practical examples.
I'll pass to my colleagues with the practically specific detail, but you make a very important point, which is been a lot of media, and we've all heard continuing commentary about the protocol, which is actually focused primarily on trade issues and movements of goods and services, or goods in particular. We're talking about people, the human beings behind this, which is our focus. And I think perhaps there's been less focus on the implications for the movement of people and the impact of the EU withdrawal on individuals, as distinct from the impact of EU withdrawal on trade movements, etc. So we see our role as very much filling that particular space in terms of the focus on people. And examples of difficulties, plenty of them.
I think the starting point that I would say, that there's kind of like two views. One, how do you enable and promote so that public authorities know the differences?
Yeah.
So sometimes we see that citizens' rights may be infringed, but not maliciously or deliberately.
Yeah.
So, for example, I heard a story a couple of days ago, a resident in Belfast who had gone to a GP and was asked to provide evidence of her biometric status. And she'd never been asked before. And it was partly because there'd been a change with one group of migrants, that there'd been some instruction to the healthcare receptionist, and it wasn't deliberate, but the citizen was going, I've got settled status, I'm able to access healthcare, I'm working, here is all of the evidence. So some of the like infringement of rights that we see is around understanding and people knowing what they can access. Other times we're monitoring where there's perception of disproportionality or balance, or a perception of, and is that the case or not? So right across the board we hear stories, the particular ones that like Helena was talking about before, access to healthcare and treatment and how you navigate that, access to benefits and healthcare and housing support that we would see. So there are some direct stories where we see the challenge. For some it will be travel, joining members, family. I don't know if there are other particular examples.
I think there's another example. I think one of the pieces of work that we do is to look at new legislation that emanates from different parts of the UK, and specifically Northern Ireland. We have looked, I think, at around between 5 and 6 sets of rules which govern student finance. So a couple of years ago we spotted a piece of legislation which updated the eligibility rules for home fee status, and inadvertently the category of persons with pre-settle status, so those who have not been here 5 years and therefore don't have settled status and permanent right to reside here, had been simply omitted. We then raised that with the department here, and they indicated quite swiftly that that was a mistake, that was an error, and they remedied that. They brought forward new rules to correct that. Now, they were able to also assure us that nobody had been adversely affected by that, because that was not the policy intention. But I think that's where we can kind of operate to help highlight where things are going wrong in one area, so that potential mistakes like that cannot be made before. And it's about ensuring that both public authorities and individuals know what to expect, know what they can expect, and know where to challenge where they're not getting what they should be getting.
Just following on from that point, Rhys, does every piece of legislation in Northern Ireland need to be screened for EU compliance?
So what we do at the IMA is to look out for key legislation that engages citizens' rights. So anything that is about the technical requirements for trailers, we would know immediately that that's nothing to do with us, and it doesn't concern citizens' rights. But anything that we see engages with eligibility for benefits, eligibility for student finance, if it's from the UK, it's anything to do with immigration, we kind of pick those up, we have a look through them, and if we feel that there is something there, we will notify the relevant department, so whichever department in Northern Ireland would be, indicate that we're looking at it, we will engage with them, ask questions if we need to, and then we will publish a report at the end of that process setting out what we found. On most occasions when we do that, everything's fine, we don't spot any issues, but where we do, we will set out what that is, and if we've been able to fix it in the meantime, we will say so, we will set out whatever commitments have been provided. But I suppose in answer directly to your question, yes, we do screen all legislation in the sense that we have parameters within which we look at, but we don't look at every single word of every single instrument, because we can dispense with a vast majority.
We feature the same in Scotland and Wales, presumably?
Yeah.
Yes.
Yeah.
I was just going to add to that, and we tried to apply a similar approach to guidance and policy as well that's issued, and I referenced earlier the civil service job rules, which was recently identified as problematic and therefore limiting for citizens with pre-settled status and certificate of application. So up until that point, for those citizens, there was an eligibility question with them with regard to making an application for a job in that sector, but we were then able to kind of engage with our contact at the Northern Ireland Executive and have that sort of grey area more formally addressed so that it wouldn't get lost, and so that actually for future to come, for future generations, that a continuity of right, with the right to work, should translate further going forward.
I think, just briefly, but those examples illustrate is that the problems that can arise here are not usually high-level, dramatic, major policy initiatives taken by governments. Sometimes it's right down in the detail of specific regulations, rules, regulations that are being constantly made by departments. And genuine mistakes, as Rhys has said, can be made, which actually impact real people's lives and affect their rights and entitlements.
Recently we've seen EU citizens' rights have struck down 2 laws that have been made in our sovereign parliament, namely the Legacy Act and the Rwanda Act. Is that likely something that's going to continue moving forward?
I'm happy to provide an initial response. I think so. They dealt with particular elements of the withdrawal agreement, so namely the protocol on Northern Ireland, and that is not necessarily within our remit. So as to whether that will continue, I think that's beyond my expertise. But I think there are some relevance to us at the IMA because the protocol sits within the wider withdrawal agreement, and when it comes to looking at how that is to apply and interact with domestic laws here in Northern Ireland but also across the UK, it is very much of relevance to us, because where it says in the withdrawal agreement that incompatible legislation can be struck down or disapplied, that same provision applies equally to Part 2, which is our role. So in some of the litigation that we've been engaged in England and Wales to date, those are the same kind of questions that come up. So what are the consequences of incompatible or inconsistent laws? How is the withdrawal agreement to be interpreted? So we have been watching with interest the developments in Northern Ireland in these cases and some others to understand how the judiciary across the UK, different parts of the UK, are treating the withdrawal agreement.
One final question. Someone was to land, a practical example, hypothetical maybe. If somebody was to land in Dublin Airport from Somalia, travel up to Northern Ireland, defying the UK immigration laws, would it be your view that that person should be allowed to stay in Northern Ireland?
Well, I think that's not directly our remit.
But,
so it's all those, well, it depends on all of the circumstances of what's gone on. So they may have come from Somalia. Have they got dual nationality? Have they got a clear claim under the immigration policy? But for the IMA's remit, we would be looking at the application of the EUSS. So in terms of are they able to make an application? Are they supported? Is due process followed? That would be, but it would be difficult for us to say.
It's a case of if the criteria wasn't met, it would be a no.
Well, it would be they'd be assuming this individual hypothetically is not an EU citizen and is perhaps is entering both Ireland and the UK, subsequently the UK illegally. They then have the option, of course, but of applying for asylum. So therefore, once they do that, they fall within the operation of the asylum arrangements, either in Ireland or in the UK.
Okay.
Yeah.
Brian, please.
Thank you, Chair, and thank you for your attendance, committee, and glad to hear you've been able to arrange some other beneficial meetings during this visit. So certainly it's interesting to hear your statistics. First question is just on those statistics. You said, I think, as applications come in, around half are approved, I think, on the first time. But you also said that the refusal rate in Northern Ireland was 13%.
Yeah.
So you said, so when people if they're not approved, quite often they will reapply, is that right? So when you say 13% is a refusal, is that at the end of the process, would you say? or
It
is
can
that
be
again
through
just
the
out of
stages.
any particular batch of applications? Or?
So the first thing I would say is it is Home Office data, and the bit that I was saying around the outcomes at the end. So it's quite difficult to interrogate at what stage. So that's not published in terms of what stage is the referral. So it's published on a 6 monthly basis. That will be the number of applications and whether they've been refused. But what it doesn't list is what the rationale is for that and at what point. And neither does it record whether it was the second application, the third application, or what the issues are. So it's quite difficult for us to respond to that because that data's not collected and published. But it indicates some questions about why that is and how we can improve that.
Okay. Some of my questions are probably more about how the scheme operates rather than just the monitoring of it, but I'll ask anyway. In terms of the actual outcome for an application, is the outcome yes or no, or are there some conditional outcomes such as a time limit or linked to a line of employment?
Yeah, I'm happy to pick that up. So the outcome, if you complete an application, you go through all the stages, would either be a refusal, so you aren't granted any status, you are granted pre-settled status, which is equivalent to limited leave to remain in the UK, which is subject to conditions such as not being allowed out of the country for a certain amount of time, or the third outcome would be settled status, which is the gold stamp essentially, and that is a permanent right to reside here in the UK.
Okay, so 3 main outcomes.
Yes.
Okay, thank you. And secondly, are certain employment categories given preferential treatment? Is there any connection to that? We don't have any. I know for some other countries outside the EU, people like health professionals are given priority and so on. But within the EU, there is no preferential link to employment? Or?
I think it's because it's the separate scheme. So it's part of the withdrawal agreement about status rather than a visa. So some of what you're referencing there is the professional visas with skills gaps.
Yeah. And I think we also have to remember that our review part 2 is about a particular cohort that were here at a particular time. Now, if you're an EU citizen wishing to come to the UK now, you will not have necessarily withdrawal agreement right unless you have a family member already here. So if you're a French citizen now wishing to come to Belfast to work, the EU settlement scheme has no relevance to you because you were not here on the 31st December 2020. And that's where the wider immigration system would apply, which could include professional visas and the like.
Yeah, and the EUSS is the practical application of the agreements, and the agreements outline the eligibility criteria, and there isn't any reference to professional qualifications or profession more generally.
Okay. And do you have any explanation for why there was an increase in applications this year? That one would imagine that the number of applications will be slowly declining over time, given that it was people who were here in 2020. But you said there was nearly a 5% increase in the first 6 months of this year. I mean, what was happening in between? Were those people just hadn't applied and were just here working, or why? I mean, 4 years later, have I had an increase?
So my half full moment is that some of the promotion work is effective. So some of that I was saying, people that didn't realise that they needed to apply, the fact that agencies and public authorities are raising awareness, perhaps some of the increases that more people are applying, or they didn't realise, so I've applied but I haven't applied on behalf of my daughter, so there might be some positives there. I think there's also what we've talked around, it can be a multi-stage process. So you apply the first time, it's not quite right, you've not got the evidence, so you need to go back in and apply, is my less full moment. So I think it's a mix of people that perhaps, for some, just genuinely didn't realise that they needed to apply. For some, that they've put it off. And for some that they've needed to do multiple applications. So I think
the other point that I would make is, I think a point that Miranda's alluded to is around the quality of the data. And I think what we don't have broken down is the nature of the applications. So if you have, say that you've been here from 2018 and you applied in 2020, you were granted pre-settled status because you were only here for 2 years and didn't have the requisite 5 years to be granted a permanent settled status. When it comes to 2023, you will have built up your 5 years and therefore eligible for settled status. You will then make your application to have that permanent residence recorded. You will be batched in the same stat to say that you're an applicant, you have applied to the scheme. So that kind of, those numbers per month can be skewed by repeat applicants who are already in the system just looking to upgrade. So I think it's kind of important to focus on the new applications which have not been part of the system. That's the kind of true. So we will have peaks and troughs. So for example, up to the deadline just before 30th of June 2020, there was a large spike in applications. They were all granted 5 years pre-settled status. It's not unfeasible that there will be similar spikes in 5 years' time from there because it will occur to them that they might need to apply for settled status. So I think we just need to be understanding of the broader context of those statistics and the deficiencies perhaps in those before possibly drawing too much of conclusions from them, which is, I suppose, our challenge really in trying to interrogate what are some of the reasons behind them.
Okay, thank you, Chair.
Thank you. Emma, please.
Thanks, Chair, and thank you all for the presentation and for answering so many questions up to this point. I think that's been very detailed. I suppose it was my understanding just from a constituency level is that an awful lot of employers were helping their employees with that, and I don't know if you would concur with that, but like I had very few constituents asking for help with this process, you know, compared to other schemes that people have had to apply for, and I suppose just to make the point that these people are obviously a very valued part of our workforce in the north, and there is a bit of anxiety, I suppose, around employers. Like the area that I represent, we have an awful lot of manufacturing business and agri-food production, and there's a lot of worry there around, you know, where that workforce is coming. I don't know if you have any comments around that, but that was all I wanted to ask you about.
So I think in terms of the employer dimension, we know as part of the kind of broader immigration scheme that employers are subject to requirements to check that their staff have the correct immigration status, and I think where in terms of the EU settlement scheme, that is a digital scheme, so employers are able to access the view and prove system to check whether an individual has rights. So I guess there is that interaction there that individual employers can see where a potential employee needs to apply, and that is a process I think they can go through. I think one of the things that we have sought to do, however, in that context is we took a judicial review against the Home Office back in 2021 and the judgment handed down in 2022, and that was all around the temporary or not nature of pre-settled status. So in our view, pre-settled status once granted would always exist. There wasn't a need to reapply within 5 years without that then expiring, because the position previously was if you applied, was secured pre-settled status, after a 5-year period, there would be a positive obligation on you to either apply for settled status to upgrade, or in some limited circumstances to apply again for pre-settled status. Now, we were able to demonstrate how that was incompatible with the withdrawal agreement, that there wasn't a need, there was no conditions that could be imposed to require people to reapply. And our concern was that there are a whole host of individuals that could be lost in the system, that they would simply forget or not realise that they needed to apply. So that was successful. But the point I'm getting to in terms of employers is that one of the key things that we wanted to secure post that judgment is to make sure that employers weren't potentially discriminating against employees whose pre-settled status may have been indicated to them that it was temporary in nature. So when they would have initially checked that individual, it would have said, this person has leave until X date, and you will need to recheck. I think that was something that we've been managed to remove, so that if you are an employee, you are subject to checks, that will just come up as, yes, you have the right to work in Northern Ireland or Wales or Scotland, wherever it may be. So that is hopefully an area where kind of that has made a slight difference.
It's interesting the point you make about the distribution of applications and constituencies. I mean, the figures show that by far the largest proportion of applications are coming from Armagh, Banbridge, Craigavon, Belfast, Mid-Ulster, Uri and Mourne and Mid and East Antrim. It's interesting that it's manufacturing sectors in particular, and we welcome employers supporting their workforce to regularise their position. It's very important. It's a very important source of support for them.
Part of our monitoring, I mean, we know responsible employers want an easy system to ensure that they're legally employing those that have got the right to work in the UK and Ireland. And so our monitoring is also making sure that that system is working effectively. If you are hiring or you're looking at your workforce, you need to be able to access that share code. You need to have confidence in that system so that you can do that. So that would be an element of our work too.
And another aspect of not just employment, but one other aspect of the work that we've done at REIS has been describing there in terms of regularising the position of certification and producing evidence is in respect of not just employment but also housing, in particular getting access to housing and being able to demonstrate to landlords that you've the right to be here, because as you know, for landlords and employers there are quite significant penalties for employing people who are not here legally, so they have an obligation as well and difficulties.
Okay, have you another question?
Brilliant. No, thank you.
I'm going to close the session to an end unless you have any burning last minute comments. No.
Well, other than just, thanks very much, other than just to, as you'll have gathered from the range of accents in front of you, we're a deliberately UK-wide body.
Great, good,
I mean, we're set up legally to cover the entire UK, and we are obliged to have representation from across the UK. So you've got England, Northern Ireland and Wales here today. We've also got board members from Scotland and also from Gibraltar. So, we are a deliberately UK-focused body.
Yep. I appreciate that. Thanks so much. I really appreciate your time today and anticipation of the meeting. Thank you.
Thank you.
Okay, members, just while we're setting up for our next panel then, I think we're moving on to item 7, which is the Assembly EU Affairs Managers come to speak to us about UK intergovernmental relationships. So page 28, your pack, you'll find the clerk's brief. Page 30, you'll find a memo from the EU Affairs Manager, and page 31, you'll find the briefing paper from the EU Affairs Manager as well. So, good afternoon, Shauna. Apologies for the slight delay there, but some of the questions were really useful.
No problem.
Shauna McGeehan, she's the Northern Ireland Assembly's EU Affairs Manager, and I just want to remind members that Shauna is actually from the Assembly's Secretariat, and her role is to advise the Assembly and its Committee on EU and intergovernmental matters. So thank you for the papers that you sent, the briefing. Do you want to make some opening remarks and then we'll get to questions?
Yes,
thanks
you
very
much. Chair. I know it's quite a lengthy paper that's in the packs there, so you'd be glad to know I'm not going to read through the whole thing. I'm just going to maybe pick out a few highlights and then I'm happy to take questions, Chair. The first sort of set of papers relate to UK-EU relations governance structures. And these are under the withdrawal agreement. There's a number of oversight bodies which were established to oversee the implementation of the agreement. And essentially there are 3 tiers of governance, each reporting upwards to each other. Understand there's a diagram, I think page 33 of your pack sort of will illustrate this maybe more clearly for you. So the top tier is the Joint Committee, and that's co-chaired by Government Minister Nick Thomas-Simons and Commissioner Maros Šefčovič. And the Joint Committee is the only decision-making body in that governance structure. The Joint Committee is responsible for the implementation and application of the withdrawal agreement, and then underneath that Joint Committee there are 6 specialised committees. The Joint Committee has the power to amend the agreement in certain areas but can't change essential elements of it, and it's that committee that provides a forum to resolve any disputes about application, and if no solution can be found they have recourse to an arbitration panel. It's the Joint Committee's job to consider whether new EU acts are within the scope of the Windsor Framework and therefore should apply in Northern Ireland. The New Decade New Approach document did state that representatives from the Northern Ireland Executive are invited to be part of the UK delegation in any meetings of the specialised or joint committees where Northern Ireland specific matters are being discussed and where the Irish Government is also in attendance as part of the EU's delegation. So underneath that joint committee then, there are 6 specialised committees that report to the joint committee, and these focus on key areas within the withdrawal agreement, and there is one of those specialised committees focused on the implementation of the Windsor Framework. The Specialised Committee on Northern Ireland will examine proposals relating to the implementation application of what was called the protocol from the North-South Ministerial Council and North-South implementation bodies, and will also consider any matters of relevance to Article 2 brought to its attention by the Northern Ireland Human Rights Commission, the Quality Commission and the Joint Committee of Representatives of the Human Rights Commissions of Northern Ireland and Ireland. Northern Ireland executive officials do attend those meetings of the Specialised Committee. And the Windsor Framework did provide for the Specialised Committee to meet in 2 new formats, the first of which is the Special Body on Goods, which talks about the legislation on goods, and an enhanced cooperation mechanism on BAT and excise. And the third tier of the withdrawal agreement governance is the Joint Consultative Working Group, and it serves as a forum for the exchange of information and mutual consultation, including in relation to the implementation of EU law in Northern Ireland. And the Joint Consultative Working Group carries out its functions under the supervision of that Specialised Committee on the Windsor Framework. The working group is the forum where the EU informs the UK about planned EU acts within the scope of the protocol, including Union Acts that amend or replace Union Acts already listed in the annexes to the protocol. So moving on, Chair, from the withdrawal agreement to the trade and cooperation agreement. Again, there's a diagram, page 36 of your pack, just to illustrate the structure. Very similar to the structure of the governance under the withdrawal agreement. The top tier of governance in the TCA is the Partnership Council, again co-chaired by Nick Thomas-Simons and Maros Šefčovič. That Partnership Council should meet once a year, and it oversees the implementation and application of the TCA. It has the power to make amendments to the TCA and to adopt decisions, and decisions are designed to be taken by mutual consent. Underneath the Partnership Council are a number of specialised committees, and these have been established to oversee specific areas of the TCA. For example, trade in goods, customs cooperation, rules of origin, SPS measures, etc. And there are a number of working groups which have been established to support these specialised committees, and officials from the Northern Ireland Executive Departments do attend those meetings. The TCA also provides for a Parliamentary Partnership Assembly, and this is made up of 35 members of the House of Parliament and the European Parliament. And the PPA makes recommendations to the Partnership Council in respect of the TCA. The new EU Parliament, the European Parliament, has set up its delegation, but the UK delegation hasn't been named yet. And members of the devolved legislatures are not part of the UK delegation, but they can attend meetings as observers. And just finally on the TCA then, there's also provision for a civil society forum which can meet once a year, and it's made up of civil society organisations who can make representations to the EU and the UK about their views of the implementation of the TCA. So, Chair, if you're happy enough, I'll move on to intergovernmental relations. We'll just run through, yeah. So, intergovernmental relations, so this is intra-UK relations where post-EU exit issues are discussed. And again, there's a diagram in your pack there on page 38. The intergovernmental relations structures within the UK used to be under the Joint Ministerial Committee structures, which some of you may have been familiar with. But following a review in 2022, this has been changed. So the top layer is the Prime Minister and the heads of devolved governments council, and that oversees intergovernmental relations, or IGR, within the UK. In addition to its normal annual meeting, the Council can meet more frequently if there are extraordinary meetings or according to need. And the next meeting is scheduled for spring 2025. Underneath that Council then there are the Interministerial Standing Committee and a Finance Interministerial Standing Committee, and they essentially consider issues that can't be considered at the portfolio level and are designed to consider cross-cutting issues. The FISC in respect of finance has its own terms of reference. And then finally in that there are interministerial groups. So these are essentially made up of ministers with responsibility for their own particular portfolio area. They've been established in a number of policy areas and they meet regularly as required, and I've included in your pack there a list of the IMGs that are in existence and when they met last. There is an annual report produced on intergovernmental relations, and it's shared with all 4 governments, but it's up to each government how they share it with the legislature. I think I did forward it to you earlier on in the year. The 2023 report came out, I think, in April or May time. And finally, Chair, you'll be glad to know then on to common frameworks. So common frameworks are being developed in policy areas which were previously governed by EU law and which intersect with devolved competence. The principles for establishing common frameworks were agreed between the UK and devolved governments, and they aim to ensure common approaches taken by devolved administrations in these areas. So essentially, it was once powers came back from the EU how the operation of these powers was going to be managed. There were a number of set principles agreed in respect of common frameworks. They were to enable the functioning of the UK internal market while allowing policy divergence, to ensure compliance with international obligations, to ensure the UK can negotiate and enter into new free trade agreements, to enable management of common resources, to safeguard security of the UK, and to administer and provide access to justice. The Minister for Intergovernmental Relations and the Chancellor of the Duchy of Lancaster, Pat McFadden, he is responsible for intergovernmental relations. The common frameworks do interact with the UK Internal Market Act 2020, and under the UK Internal Market Act, exclusions can be arranged through market access principles where if one region of the UK wanted to make a rule around banning something, then they can seek to have an exclusion so that they do have that element of flexibility about local policy making. Due to the differing devolution settlements, each devolved administration has a different number of common frameworks in which they participate, and out of the three devolved, the largest number of frameworks apply to Northern Ireland, so there are 32 common frameworks that apply in Northern Ireland. And obviously the provisions of the Windsor framework have to be taken into account when common frameworks are being developed. The Cabinet Office had previously set out a 5-phase delivery plan for how common frameworks are designed, reviewed and implemented, and there's a flowchart of that in your pack. And the process does include a stage for each legislature to be able to give their view on the common framework. And within Northern Ireland, obviously the committee or the Executive Office has oversight of the general programme, and then each statutory committee will scrutinise frameworks in their own area. The Executive has previously indicated that sign-off on frameworks is a cross-cutting issue and requires sign-off by the entire Executive. And to date, only one common framework has been fully implemented in the UK, and that's around hazardous substances planning. The majority of the rest of them have been operating what they call provisional mode. They're awaiting final sign-off by the Northern Ireland Executive. So, Chair, that was a very quick gallop through that quite long paper there, but I'm very happy to take any questions.
Thank you, Sean. I just want to pick up on that last area around the common frameworks. So when we were at the Interparliamentary Forum, when was that? Maybe March or
yeah, that's yes. Right. Yeah.
So it was quite an embarrassing meeting in the sense that all the other devolved regions had signed theirs off, and we had the excuse that we hadn't had a devolved executive here for 2 years, but they're coming here on Friday. What is the excuse for why they still haven't been signed off 6 months or so later?
Very good question. From speaking to officials in the other legislatures, the situation seems to be that the frameworks, to be fair, are all operating. Yes. They're purely just in provisional mode. Whether that has impacted on their operation or whether it's just terminology, I'm not quite sure. But yes, they're all still waiting a sign-off by the Northern Ireland Executive. I understand that the other devolved governments are all content.
So just to tease that out a bit, so I think you indicated there that they had all been sent to their relevant committees for their own scrutiny, input, etc. Yeah. In terms of how you've presented them in the table there, provisional confirmation, so which of those have gone to committee, come back and are now sitting in an in-tray in the Executive Office?
As far as I understand, all of them have been to committee at some stage. There's 2 in respect that will lie within the Department for Economy in terms of their remit. They're not responsible for them. They're obviously developed in the UK. There's 2 that are policy still under development, but all of the committees should have received something from their departments on these at some stage. They're all at various sort of stages of development, but most of them will have been to committee in provisional format.
And back again then?
Yep, should have been back, yeah.
Okay, so we wrote, sorry, just to bring in the clerk here, so we wrote several months ago and asked for the status.
All the committees, yes.
So I think we may have to go back and ask. Hopefully we'll get a response before Friday. But anyway, so that's really quite frustrating, because there's some really good areas there that we really do need to tie down that impact on people's lives. So just to move on a little bit then, in terms of sort of the intergovernmental issues, the wider ones then, are there any other, I know you would liaise with your counterparts in other parliaments. What are the sort of key issues that they're finding in terms of the new arrangements, in terms of intergovernmental issues that need to be dealt with?
I mean, there's lots of the other administrations will have made public commentary about how well or not they feel the structures are working. I think it's probably fair to say that the previous system of the Joint Ministerial Committee there was lots of issues around the frequency of the meetings and who attended them and the importance that was accorded to them. So I think that was the reason for the review back in 2022. And this new structure was agreed between all the governments. So I guess with the change of government as well, we'll wait to see how well that is working. I know that, for example, the previous finance minister met quite often with his counterparts to discuss issues around the Shared Prosperity Fund and the devolution of funding and things. So I think probably a lot of it is driven by circumstances in terms where there's an issue that they're useful for them to get together. But I mean, the interministerial groups seem to be meeting quite frequently. So I guess that's probably where the bulk of the work is done, and then you'll see the ones with the Prime Minister obviously have a lot more profile, but that's not to say there's not lots of work going on sort of behind the scenes.
Yeah, of course. I suppose that's the next point I want to bring up, and that's in terms of the role of the Joint Committee and those people who are maybe not even chairing it, but those people who are feeding into it in terms of raising awareness or concerns about what's happening in Northern Ireland in terms of some of the difficulties, especially compounded by the fact we had 2 years without devolution operating here. So it's just really about how our issues are being fed in, and it's our full recognition of the sort of particular circumstances here in Northern Ireland in terms of making this work for better for worse.
Yeah, I mean, I think that the ministers obviously have been at those, and obviously then there's also the East-West Council that has been established. So I've put in the packs there the details of sort of the various meetings and who's been at them and when the next meeting is. So with a lot of these things, I guess, it may be worth the committee seeking feedback from the department about what their assessment is of the value of the structures and what they're getting out of them.
That's useful, thank you. That's a good suggestion. Go ahead, Deputy Chair, thank you.
Chair, just going back to your question around the Collin framework, areas that are described as provisional confirmation from departments here, ERA, economy, health, finance, infrastructure.
Yep.
All or most of that has been to the committees.
Yep.
Has there been any controversy or comment or concern expressed in the committees about any of that work?
Not as far as I know. I mean, some of them were very much reviewing them and saying they were content, but obviously wanted to keep an eye on them and monitor them, and most of them do have monitoring and review mechanisms built into them.
Once content, then they
go back to the governments to get sort of final sign off then.
Okay.
Yeah.
So in those circumstances, while committees here are doing their work, it disappears into a black hole in the executive office. Is that what you're saying? Well, I'll certainly say it.
You may say that.
Thank you. So I think, Chair, you're right. This is indeed. It might have been an excuse in the past to say that we hadn't been here, although that itself is not an excuse.
Yes.
But nevertheless, 6 months on, I think the Executive Office will be in an extremely embarrassing situation should they attend a meeting and not be able to explain why all of this, despite the fact that committees have, by and large, effectively cleared this as mundane and perfunctory work.
Any other questions?
No, that's fine,
okay.
thank you.
Sinead, please, online.
Actually, I think you've answered it, answered the question, Shauna. But are there any other aspects of the work that you could, about the approach of the executive? Are there any other aspects that we need to be concerned about at this particular stage so that we can see the totality of it? Shauna?
Is this in respect of intergovernmental relations, Sinead?
Yes.
Yeah, I mean, I think, as I say, those sort of new structures were only really came out of the review in 2022, so they're quite young, really, in the grand scheme of things. So I mean, in terms of, it, as I said to the chair, it's maybe worth sort of saying with the executive what their assessment is of how well those structures are working. And to be fair, they seem to have ministers, especially at the interministerial groups where I think probably a lot of the very practical discussions take place, ministers do seem to be attending those on a regular basis. So obviously I'm not at those meetings, so I have no idea what their assessment of the value is. But the fact that this structure was agreed with all the governments, you would like to think that, that they're fairly happy with the structures, but I couldn't sort of make an assessment of the value really.
Right, and how is the effectiveness of the structures measured? Because I really can't get a handle on that.
Yeah, so the intergovernmental relations structure within the UK does have their own secretariat. So as I said, they do an annual report. It does lay out like the number of meetings that UKG will have had with the Northern Ireland Executive, with the Scottish Government and with the Welsh Government, etc. But obviously numbers are only part of it. The numbers in and of themselves don't necessarily capture good conversations and sort of the more softer outputs that might be happening behind the scenes. So I think the issue with intergovernmental relations as a legislature is difficult for us to scrutinise it, because there's not a lot of the conversations obviously are taking place at official levels and there's no sort of formal minutes or those kind of things, so it's very difficult to see outputs, and unfortunately that's just the way the system is set up, and the annual report really is the only output formally we're seeing from the structures as a whole. So I mean, it would be up to the committee obviously maybe to, as I say, seek the view of the executive. I'm not sure if the executive even made the IGR report available to the committee. I know it is publicly available, but whether it was flagged up to you that the 2023 one had come out.
I think we did get it actually. Yeah.
So that's I mean, like I say, it's because we're not seeing a lot of information doesn't necessarily mean there's not meetings going on, but it's very hard to sort of scrutinise that effectively whenever the transparency of information is a bit limited.
Yeah, and it's the fact that the Joint Consultative Working Group, the meetings, they're confidential, and you just don't feel as if you're getting the transparency. Maybe there's nothing too much to see, but how would you know? So no, it's really just about that transparency piece. Thank you.
Thank you. Timothy?
Thank you very much. Page 33, 36 and 38, we have some nice diagrams, very nice, well presented, colourful ones. Looking at it, I have a real concern. So you said in your opening gambit that the Joint Committee is the only decision making forum.
Yeah.
So we have all these other bodies essentially highlighted in each of the diagrams where, meetings about meetings, talking shops without any real decisions being taken. It reminds me very much of plenary and Stormont, where you can have all these motions, and we heard the Minister saying the other day that if a motion is passed, he doesn't have to act upon it essentially. And we seem to have a very similar situation here. Where in any of these diagrams is there input by the people of Northern Ireland into the laws that are being made?
So the Joint Consultative Working Group, which out of those, in terms of the withdrawal agreement, is the sort of third level. They do have a number of structured subgroups on themes. There's ones around agri-food, there's one around customs, and they are able to bring in stakeholder groups and sort of experts and things. So I guess sort of stakeholders who might be experts or have particular concerns can go into those structured groups. But as Sinead was saying, there's no minutes of those groups because they are necessarily with officials. So it's very difficult from the outside looking in, I guess, to see what's happened and the quality of that discussion. But, some things, obviously the nature of a lot of the discussions, there has to be room for confidential meetings. But again, it's very difficult to know. And if you were a stakeholder looking in from the outside, how easy that access is to those groups or, to put your point of view, I'm not sure.
It really does give the appearance of talking shops. Page 31, A, Joint Committee. The packet says Joint Committee deals with the implementation of EU VAT rules in Northern Ireland. So very much we're 248 years after the American Revolution. and we in Northern Ireland are subject to taxation without representation, essentially. I want to make that point. Page 40 of the pack, Common Framework, bullet point 3. Common Framework helps ensure the UK can negotiate, enter into and implement new trade agreements. So, in the event of the press speculation being correct, we've heard a lot of good and warm comments about the new Trump administration wanting to do a trade deal with Northern Ireland. Is your understanding that Northern Ireland can fully benefit from that?
Well, the UK government has set out that nothing in any future trade agreements should mean that Northern Ireland should be excluded.
You're content and confident that'll be the case. So when we would hear coming out.
Well, I mean that's the UK government's position. I couldn't comment on whether I'm content or not with that, but that's their factual statement that they've come out and said there should be nothing that would prevent Northern Ireland being a full participant in any free trade agreement. But obviously there are specific issues that would have to be looked at around Northern Ireland because of the withdrawal agreement and the Windsor framework. That would obviously have to be a factor in the consideration of any free trade agreement.
Which may limit what we can avail of, and that brings us back to you have all these diagrams with all these meetings and these structures with no minutes. And I certainly would be very concerned of what will come out the other end of them. It seems to be a very closed house and not transparent in the slightest. But there we go, that's my concerns. Thank you very much.
Thank you. Brian, please.
Okay. Thank you, Chair. And thank you for the report, which is very useful reference.
Okay,
and some of these structures are, as you've said, are UK-wide EU structures, and some are more specific to the arrangements in Northern Ireland. When I speak to groups, I always tell them that Northern Ireland isn't the problem. It's having an open border, land open border with the EU is the problem. And politically, as unionists, we have sought to undo the damage of the Northern Ireland Protocol to restore Northern Ireland's place within the UK internal market. So I would hope that the complexity that Timothy referred to actually means that there is a focus on the various sectors where there was previously those problems and where action is needed to restore our place within the UK internal market. One area which is highlighted, and I don't know whether you can comment on it specifically, is in horticulture, around plants, and I see there on the common frameworks, a number of sections there, plant varieties and seeds. Mm-hmm. So I don't know whether you see there you have the status provisional confirmation. Mm-hmm. Are you able to comment on any of the outworkings of those frameworks and of the committee structure there in terms of addressing issues that have been raised by various sectors of the economy?
So when the common frameworks are first, the genesis really of the common frameworks process was a mapping exercise the UK government did to see where EU powers intersected with devolved powers, and that's how they then grouped these, come up with these themes and these specific common frameworks. So the process of when the common framework was initially designed, that one, for example, that you mentioned there around the plant varieties, will have involved consultation with the stakeholders to see what the issues are in that particular sector. So they should have been able to feed into the operation of the common framework, but as I mentioned to Mr. Dixon earlier, there are review points and evaluation points built into all of these. So the idea being that you could have an emerging issue, the framework could be signed off and agreed, but there could be an emerging issue, a new variety, a new disease, whatever that may be. So the process of common frameworks is designed to be able to stretch and flex to take account of that, but then the whole idea of the common framework is to manage intra-UK trade so that something happens in Scotland, it means a Northern Ireland producer can't sell to stop that kind of thing happening. So that's the idea of the framework. It is meant to be slightly elastic so that it can flex, and stakeholders should have been involved at the initial stage. But as I said, there's review and monitoring periods built into all these. In terms of more detail on that specific one, the Agriculture Committee will have looked at all of these and made some comments on them. I can't off the top of my head remember what they said about that one, but there will be commentary on that.
Mm-hmm. Oh, and I hope that will be the workings of this, that there will be bodies that will be picking up constantly on issues raised within the various sectors of the economy and working to resolve them. And we were told that the Northern Ireland will be able to avail of the trade deals that the UK is doing now with more than half the countries in the world. So also, again, political comment, but I've always said if we have an access to the EU market, that can't be at the expense of our place within the UK internal market, and that's what we'll constantly seek to make sure is in place. But anyway, okay, thank you.
Thanks, Chair. Thanks, Shauna, for the briefing note on the presentation. Firstly, can't believe me and Brian agree that the border's the problem. That's the first.
Open border.
I suppose I just wanted to comment. We were obviously in Brussels last week as part of the other committee that I sit on, the Windsor Framework Committee, and I was sort of struck at the level of knowledge within the different bodies that we met over the course of the 3 days around the specific issues that are faced in the north, and the level of what way would you say, almost ability to and willingness to compromise and to try and find solutions, and was really impressed by the good grace that we were shown. So I just wanted to make that point. I think you've laid it out well in this document, and I suppose we're conscious of the loss of funding is the biggest problem that we find locally around our leaving of the EU, but the different changes that are coming in, particularly to the agricultural sector, and how we're trying to work our way through that. So it's just a comment really, but just appreciate the briefing and the work that I know you're doing, and the team out there who are really doing a lot of work that probably hasn't always been appreciated by us in this committee. Thank you.
Thank you. I have a question that's not necessarily in your briefing, so you don't have to answer it, but I think it's a live issue, and it's really around the democratic consent motion and Secretary of State's movement in that over the last couple of weeks, and the potential then, obviously, for the vote. Is it the 1st of December? Is it coming up, or is it 1st of January? Anyway, that's not the question as such, but it's whether if it goes through by a simple majority, then the UK government then has to set up a commission then to look, etc. What committee within this legislature would that would feed into that? Would it be this executive office, or would it be the Windsor Framework, or would it be economy, for example? So the UK government will commission an independent review of how the protocol and Windsor Framework are working, and the implications of how to choose to continue or terminate alignment will impact on social, economic or political life in Northern Ireland. So my point is, who would be feeding into that, and where would the accountability mechanism be within this Assembly?
So firstly, the motion will be just treated like any other business motion,
Yes.
a regular motion, and the Business Committee will schedule when that takes place, depending on the laying of the motion. In terms of what comes afterwards, as you rightly say, if the vote is passed by simple majority only, i.e. not with cross-community consent, the Secretary of State is under statutory obligation to commission an independent review within 1 month of the vote. Yes. And the terms of reference, as you said, will cover that. In the unilateral declaration on the democratic consent, which members will recall is a hangover from the original protocol, it's still within that. The review will consult with political parties. So it'll be more through political parties, civic society, businesses. That consultation will be done in that way.
Okay, thank you. Go ahead.
I ask a quick question that you don't have to answer on the back
of it. Sorry. Should have given you forewarning that this was topical. Go ahead.
Remind me, there is a difference in terms of this being brought back to the Assembly again, whether it's a positive or a negative vote. Am I right in saying that?
The main difference is that if the motion is passed by simple majority only, the next vote will be in 4 years. If it's passed across community consent, the next vote will be in 8 years.
All right.
Okay. Okay.
There's briefing notes from the presentation yesterday.
I know. I suppose some would argue that to somehow give this Assembly democracy, you might not want to pass the vote. because the opportunity for it to be put to us again would be sooner rather than later. Am I wrong in saying that?
But you get a review.
You get the review as opposed to
No, I suppose the timing for me is I would rather be put
4 years
to the Assembly within 4 years than 8.
Yeah.
You know, and the outcome of that might determine how I might vote.
Yeah, it is something that it's very live, obviously. Did you want to come in, Timothy? No? I thought you did. Okay, thank you so much, Shauna, for that presentation today and for all your preparation. Okay, members, let me just find our place. We're now going on to the departmental oral briefing on the October monitoring. You'll recall, well, first of all, page 45 of your pack, you'll find the clerk's brief. Page 47, you'll find the briefing paper on the October monitoring. And then page 57 of the pack, it's the October monitoring form 2024-25. So we have two officials from TEO today. Do you want to go and sit there?
Okay. I'm supposed to be going to this Joe Kennedy thing at 4:30.
It's 4:30. Yeah. I'd like to get to that.
I know. I really don't care. Well, good afternoon. Good afternoon. I think we're a wee bit ahead of schedule, so apologies about that. But so, members, we're welcoming today Ronan Murda, who's the Director of Finance, and Paula Shearer, who is the Head of Budgeting, both within the Executive Office, and it's specifically in relation to the October monitoring today. So thank you for your papers. We had them in our committee packs last week, and it was just, I think, that the members had some questions in relation to those, but I'm not sure, do you want to make any opening remarks or speak to them?
Okay, thank you, Chair.
Thank you.
Many thanks for the opportunity to provide the committee with an update on the financial position of the department and the outworkings of October monitoring. A written briefing has been provided to the members, which I hope has been helpful, but we're happy to be here today to answer any queries or provide any further detail from the paper, and apologies for the lateness of the paper, just to acknowledge that. If there's any details about or questions about operational delivery linked to any of the issues in the paper that the committee would like to receive more information on, we'd be happy to follow up with written briefing or to get some more information. At the last attendance in June, the outcome of the June monitoring round wasn't known at that time, so we've taken the opportunity in the paper to provide an update of both June and October monitoring. The financial challenges for the executive continue. In response to the bids submitted at June monitoring, the department was allocated £2 million on an earmarked basis, and that was specifically for good relations and communities in transition. So both of these are directly solely towards frontline delivery. None of that money goes towards the overcommitment, which we are continuing to manage during the year. And at the end of June, the overcommitment stood at 1.2 million. October monitoring was commissioned, and again we reviewed the position for the department for the department and our ALBs, and the instructions asked that we focused on additional reduced requirements, changes to the overcommitment or non-contractual pay costs, and bid for specifics around ring-fenced resource DEL, which is effectively depreciation and impairments, and capital DEL and FTC, which we've done. In addition, there were technical adjustments and reclassifications. Previously reported pressures recorded in-year information gathering did not require submission of a bid, and we continue to plan to manage within our allocation for non-earmarked resource DEL and report a pressure of £7 million in terms of victims. And we've provided the information required in terms of capital, FTC, AMI and non-budget. The result is that the non-earmarked resource DEL now stands in terms of our overcommitment position at 0.6 million, so it is reducing through the course of the year. In terms of earmarked, during the normal course of events, it's victims payments, HIA and truth recovery, but given that there were earmarked allocations in June from the executive, that means that now includes money in respect of both good relations and CIT. Treasury earmarked funds were allocated during the period as well for CIT, as well as Windsor Framework and dedicated mechanism. And we continue to register the pressure of £7 million in terms of the demand-led area of victims' payments. And capital, we've registered 2 bids, the NSMC lease and progress in terms of urban villages. So happy to take on board any questions or answer any queries you might have.
Thank you. Sorry to distract you there. I was just trying to get clarification from the clerk on something, but thank you. Do you want to make any comments, Paul?
No, I'm okay.
Okay, thank you. Okay, so I just wanted to pick up on so the reduced requirements, and you state in it that there's the permanent HIA memorials agreement on these have not been reached at this stage. Where work can be progressed in 2024-25. Can you speak to that? Because obviously there has been a process ongoing for 4 years now, at least, where the victims and survivors have been temporarily engaged with and then left in the dark. I'm just wondering what is happening with that process.
Essentially, the budget that was there at the start of the year had been an indicative allocation, and that was an allocation put in place before the return of ministers. So it was one that was arrived at by officials along with the victims groups. So with the ministers are keen to engage directly within the groups and to have that consultation and hear from their proposals. So that's why it was felt that that process was going to need slightly longer time, and therefore, given the passage of time through the year and the pressures felt by the rest of the bloc, it was better to surrender that amount, and it would fall into next year.
Could you remind us how much you mean by surrender? How much was it?
180,000, 0.2.
Okay, so that would be more just for the engagement process as opposed to all of the delivery, or is that what you're anticipating? The whole will include the memorial itself, memorials?
That was capital for the memorial itself.
Capital for the memorial?
Yeah.
Okay, because I think the groups are keen to see that progress in terms of even just the revenue side of it, in terms of the commissioning of the Arts Council. Okay, so just staying in that field then, so we heard this week, for example, that some additional payments have been made by religious orders in terms of the redress, contributions towards the redress scheme. Where are these contributions showing up in the accounts, and how are they going to be taken account of?
As I think referenced in the paper, they are factored in the current forecast requirement for the year.
Okay.
Negotiations are ongoing.
Yes, I know they are.
So apologies if there maybe isn't that fulsome specifics in terms of the detail, but they are factored in terms of the level that's expected, but negotiations continue through the year.
I suppose we as a committee are frustrated that we know, what was it, 92 million has already been paid out in the redress scheme, possibly up to 96 million. You know, have they contributed 10 million, 50? We as a committee have absolutely no idea where we are with this.
The ministers have committed, once the negotiations are at an end, to make a full publication of the amounts that have been agreed at the end of the publication.
Okay, but so it'll be easy to find then when. Okay. And sorry, just a wee quick one then. So what proportion of the money paid out, as I said, it'll probably be 92, 96 million. What proportion are you working on in terms of recovery for the public purse from the institutions? Have you set a target on that?
Oh,
you don't know?
That's getting into the detail of the negotiations. Apologies.
Okay. I have another question, but I'll move on, and if somebody else doesn't ask, I'll come back to it. Go ahead, Deputy Chair. Thank you.
And again, it's in that area, and I appreciate why you can't disclose the figures, but nevertheless, are the First and Deputy First Ministers and those civil servants who are negotiating with the organisations for this money aware of what the public expectations are around those negotiations in terms of maximising the income?
I think absolutely they would be. I think they would need to answer for themselves, and I believe that there are officials due to correspond and attend the committee on that specific subject. But yes, they're very much aware in terms of the expectation in the public domain in terms of the need for contributions towards the cost.
I just hope that message sinks in deep. Thank you.
Thank you. Timothy, please.
Thanks very much, and thanks to the clerk for his very helpful briefing note that he's provided. You have mentioned and apologised for the papers being late. Can I just ask, why were they late?
Well, in terms of the papers, the October monitoring deadline was the 25th of October. Not getting into all the specifics. I mean, in terms of everything that needed to go through, ministers needed time to consider the proposals in terms of the monitoring round. As you'll appreciate, many of the issues that ministers deal with and engage with the committee upon require political engagement, and so they do take that bit longer in terms of resolution, and that is particularly with regard to the budget process. And the executive office is slightly unique, more so than other departments, and it can therefore take more time to get through the process.
My short time in this committee, the table papers are late on a constant basis. The information that's sent to committee is usually quite late in the day, or at the wire, and that would be a concern I would have. There's a constant history and a constant trajectory here of the information as provided late to committee. But moving on, page 48, paragraph 14, dealing with the Victims' Truth Recovery and HIA. Are the payments being sped up in relation to the victim's pension? And do you know what the delay is between an application being approved and the payout?
Don't have those specifics in terms of performance, but we could certainly come back to you for detail. The department has worked with the Victims Payment Board and all those involved with delivery in terms of improving the turnaround time, the throughput in terms of applications from the point of a determination being made right through to redress. So it is an area of focus where we do provide additional support through Victims Payment Board and VSS to applicants in order to make sure that the focus is on victims at all times in terms of delivering redress as soon as possible.
Well, I could add that in 24-25 has seen an increased number of the panel members, so there's been more determinations looked at this year as opposed to last year, so the process is speeding.
Yeah. If we could get that information regarding when it's approved, when they get the payments, that would be helpful. Page 48, communities and transition. There's 2.2 million associated with it. I suppose my initial thought would be, is that not more of a justice issue? But when it does sit in the TEO budget, can we get a list of where that money's going to? A list of groups that's in receipt of that?
Earlier on in the year there was an updated list
Maybe
in terms of
missed.
Earlier in the year, I think in May, we provided that level of detail for the committee, but I believe that was for the 23-24 year, so we could certainly get that similar breakdown now for the current year.
Page 49, dedicated mechanism and Windsor framework, 1.5 million. Can you give any details of what that money's for?
In terms of 1.5 million?
Yeah.
0.1 million is for the EU Legislative Information Tracking System, EULITS, 45,000 for specialised legal support for mapping and transposing EU law, 233,000 for dedicated mechanism team, and 1.1 million is dedicated mechanism for ECNI.
Page 51, regarding the maze. Is it possible for the committee to get a breakdown just for the maze regarding the maintenance of the prison buildings and hospital wing? Is that something you can do?
We could certainly engage with Maze Cash Development Corporation to get that level of detail.
Page 52, in regarding following on from what the chair has said and the question from the vice chair, there's obviously 92 to 96 million anticipated coming in. What steps are being taken to recover money from those not willing to pay? And is that factored into this figure that we're intending to recuperate within this financial year?
We wouldn't anticipate money coming in where there isn't a reasonable expectation of a recovery. Because
at this stage, we're only anticipating the money coming in from those that have engaged in the process.
Just before you go on, Timothy, I think we will raise this next week with the officials, because I think that we need to have draft legislation ready, or you should have draft legislation ready, so that if the deadline passes for the contributions not to be made, that you're ready to go, so we don't have a big long wrangle. Anyway, just put them on notice. Thank you.
Page 53 talks about a pressure of 6.4 million from service delivery for refugees and asylum seekers. So that's money coming from the Home Office?
That features at the moment in that way because the money doesn't transfer until spring supplementary estimates from GB departments.
Is that 6.4 coming to TEO directly, or is there other money going to, say, health, education, communities?
That would be the money. This is purely the TEO budget we're talking about.
Yeah.
So there would be the other departments are involved in delivering those schemes.
So the 6.4 million that's coming is just for the TEO
yes,
aspect.
That would just be the amount of money that stays in our budget.
Page 53, NMSC lease. Can you tell us who the lease is with?
It's for the building in Armagh.
The actual name of the landlord on the lease, no, but we can get that.
Could we get some details around how long the lease is for, how large is the property?
The lease is for 10 years.
It's for 10 years. Can you tell me, do you know of any plans for accommodation for Intertrade UK coming up? So,
not aware of any plans, but I think that goes through what was Department for DLUC Housing or Homes. Anyway, GB department rather than ourselves.
A couple of references in your evidence to the Windsor Framework funding website and the fact that it came in under budget. Can you tell us what the function of the website is and when it will be operational?
I'm not sure if we have that level of detail with us today, but we could certainly get it for you.
All I know is that it was for the developments to the EU legislation information tracking system, which the cost has just come in less than had been originally anticipated. But we can definitely get more details to let you know exactly what it's for.
Essentially, that system is to play a key role in informing ministers, MLAs, and in particular the Windsor Framework Democratic Scrutiny Committee on new EU laws and replacement laws.
So it's an internal website essentially for the executive MLAs, within house and the intranet, as opposed to information.
I'm not technically okay with exactly where that sits, I must admit.
Final question then. Recently asked the Finance Minister about the new head of regulatory divergence. To my surprise, the Finance Minister came back and said that was a position requested by TEO. Is there any other staff employed by TEO regarding the protocol, Windsor Framework? What size of staffing is that attributed to the TEO committee? I was surprised that when it was a post requested from the First Minister and Deputy First Minister.
Well, but it's a function within the department in terms of providing advice and support, so there are staff that are involved in that function. So it certainly is, there's activity within the department specifically relevant to the Windsor Framework. And so
there is a structure that exists within the executive office essentially regarding and dealing with them issues.
Yes, that would be. There's a few areas of the department that would be involved in that specific delivery.
Then would be all new posts. Is there any possibility I could get information on that? Size of the structure, cost of the structure, number of people employed in the structure? Thank you.
There was a session, but the gentleman who was here at the end of the table in terms of the EU affairs, he didn't get that many questions asked to him, but I think that was our very, very early month, so we can maybe ask them to come back to give a bit of context in terms of the breadth of the operation, if you think that would be a good idea.
That's grand. Thank you.
Okay. I have two more to come in and then I have a couple of questions to come back with. Carol, please, and then Brian.
Thank you. I just want some more information on the FTC. I think it's on page 49 from paragraph 20 to 23 in terms of what SIB are using the FTC for in terms of loans, private equity loans.
Yes,
so
certainly. FTC was introduced by the UK government in 2012-13 to boost investment. So it's a specific funding, ring-fence funding, with the intention of stimulating private sector investment in projects that are going to benefit the region. And it's ring-fenced and controlled by Treasury, and the funds can only be used to either grant a loan or to an equity investment in a private sector organisation. So it's used across the NICS, across a number of departments. So communities, for example, we'll use it in terms of delivery of co-ownership.
They use the co-ownership, but what I would like to know is, could we have more detail on where these loans and investments are made?
Well, within
SIB.
within TEO, We're involved in the delivery of FTC funding on behalf of two departments, Department of Finance and Department for the Economy, specifically because they don't have the legal vires to be able to administer the loans themselves. So in terms of DFE, loans in respect of the two universities pass through SIB. SIB have been established as having sufficiently wide legal vires to be able to administer those loans on behalf of the department.
I get that. No, I get that. I'm sorry for interrupting you. What I would like to know is where the FTC has been invested by SIB and who to and how much for.
Well, we could provide a detailed breakdown. There's the, in terms of the universities, on behalf of DFE, gross loans issued have been 158 million. This is all appears in our accounts. It appears in the TEO group accounts. And in terms of...
To universities, is it the Ulster University in Queen's?
Yes, Ulster University in Queen's.
And what about Derry? Is it in McGee? No?
No, I don't believe there's any FTC funding applied to Derry. I don't think so.
Okay.
But I can check that. For DOF, we administer the funds via SIB in respect to the Northern Ireland Investment Fund. And that's a specific funds delivered through CBRE by Department of Finance.
Okay, and sorry, no, that's fine. My last, if you could come back and let me know, just in terms of, what funds have been invested in the Northwest, I would appreciate that. The second part of my question in relation to the Strategic Investment Board is, I asked some time ago what the Strategic Board involvement was in terms of the End and Violence Against Women and Girls strategy. I've yet to receive that information, or indeed the breakdown of money used on staff as a part of development of that strategy, and if that's still the case. So I'm just respectfully asking if you could bring that back to the department. I would really appreciate it. Thank you.
I was advised that that response had issued. Committee not received. Apologies. I can chase that up, but I was advised that that response had issued to the committee.
Thank you.
Okay, thank you. Brian, please.
Yep, just one question. Glad to know. Just on page 53, where you say about a £1 million bid from urban villages. I don't know whether you know which project that is in relation to. Certainly, we're awaiting approval of funding for Westland Community Centre. So I don't know whether you have that now, or whether we could get an update on that of funding for that new community centre.
In terms of the community centres and the overall urban villages, by way of update, it was anticipated at times of submission to October monitoring that if the bid was unsuccessful, that there could be a difficulty. In terms of managing urban villages throughout the year, there has been a delay in the award of contract on Ballysillan for a few months, and that actually means that the purchase of equipment could be managed to next year, which means that the delivery could be managed within means on urban villages. So the briefing had indicated that there could be a stall put on some of them. Sorry, the name of the project again?
Do you mind talking about Ballysillan playing fields?
Yes.
Which we understand is to commence this month. Are you saying
yes?
Right, that's fine.
Oh, no, it still is progressing.
Right,
but just in terms of the timing, yeah.
Long awaited, but the main contractors appointed, and yes, we're told that is due to commence now this month.
No, it is absolutely.
So Westland Community Centre is a project that's been awaited. At one stage, it didn't have a budget allocated towards it. So.
I don't have any details of Westland Community Centre. No, nothing profiled at the moment, but I can follow up just exactly when that's planned.
Okay, no, I appreciate that. Okay,
thank you.
Chair.
Neil, did you want to come in, or?
Yes, please. Just a wee quick question as well. See that 0.5 million was set aside for the delivery plans for end violence against women and girls. It's secured through the DFE Small Business Research Initiative. So does that mean that no public funding other than that small amount was actually allocated to the end violence against women and girls in this monitoring round?
I should probably just walk through the allocations for ending violence against women and girls, because obviously with the framework and the delivery plan now launched, and its features highly in the programme for government. At the start of the year, there was an allocation of 0.9 million for ending violence against women and girls, and then that additional amount, which was set aside from the main estimates allocation at the start of the year, was the $500,000, so that brings it to 1.4 million. The 500,000 capital SBRI, that is completely separate, so that's capital money as opposed to resource. So
Right.
that's over and above. It's separate money.
Okay. That's great. Thank you very much for that, Roland.
Thank you. Claire, please go ahead.
Thank you, Chair. It's just really to pick up on the point around the funding for violence against women and girls. I expect there's a point in which the money, particularly for this year, has to be spent. So how are you, I suppose, getting that money out to be spent, most importantly, for meaningful projects or outcomes that will actually have an impact in terms of what we want to achieve with that?
Well, the delivery plan set out this year is primarily focused about the initial stages of the change fund. So there's going to be allocations to grassroots projects in order to get the money out to better equip capacity building and focus on prevention, really. And then we'll move on to the regional change fund, which will focus towards regional expert organisations to support awareness training, prevention and capacity building work.
Okay. And in terms of this funding, is the department giving any sort of steer or advice to grassroots, potentially councils, on how to spend this money? Speaking with people, they're not quite sure they're getting any direction from the department about what to do with this money. It's just a case of we need to spend it by the end of the year.
There'd be a bidding process and an assessment of business case process for any applications to which projects would be allocated funding. So that will be part of the process through councils.
Yeah, potentially. But so will there be terms and reference in terms of what we want to achieve from what this money will be spent on? That type of thing. It all feels very high level currently. And it doesn't really seem that there's any sort of ideas about how to actually address violence against women and girls. It's just, let's spend this money to demonstrate action. But, for me, certainly, who has an interest in this area, I would like to see outcomes from it. And I wouldn't like just to think we're going to pass 50 grand to a council and say, spend that, by the end of March. What is the department actually saying we need to do? The tangible, realistic, to ensure that this happens on the ground. And I'm not entirely sure that councils themselves will know. I don't think any of us knows. That's why we have a strategy. But I would expect more of a lead from the department in that, so that we can get this on the ground and make real value of it.
You can certainly take that back and get a briefing note.
I was just going to draw members' attention to some correspondence in the pack, page 104, and there's some outline of where some of the money's been spent: communications and engagement specialist advisor, data scientist, associate strategic advisor, etc. So it might be something that we in the new year ask them to come and. Sorry, go ahead.
I was just going to say, I'm very supportive of what Claire's been saying in respect of this.
I'm not minimising what you're saying. I'm just saying that we know who to bring in.
And indeed, the list of activities that you've just referenced fills me with horror. Yeah. What we don't need is more specialists and experts. What we need is practical grassroots support in terms of this. We need to be looking at those organisations in communities that are actually delivering. That's where we need to be going, not more fancy strategists being paid for.
Is that the response from the EVOG team in terms of the SIB funding in particular? So I think that's separate.
Okay, well, I think we maybe need to get our heads around it. It's probably the point. I just want to ask one question, and it's in relation to the June monitoring round. And at the time, I expressed concern that we weren't being given enough information about where the pressures were. And I raised the issue around, or actually, I think it was maybe you, Brian, and I came in behind, in terms of the transformation delivery unit. And the June monitoring round allocated, the bid was in for 1.5 million. And I'm just wondering, have you any update for us in terms of whether that money has started to be drawn down, in terms of whether there was real pressure in June that's now being met in terms of going
In terms of the delivery unit, the pressure wasn't met, as we know. So the only money that came to the department in June was the 1.5 million for CIT and 0.5 million for good relations.
Okay.
So as set out in the programme for government, the delivery unit is linked into the transformation delivery unit. So there's 2 members of staff in place now. So
okay.
Discussions are ongoing, and I don't believe allocations have yet been made in terms of the transformation fund itself. So the expectation is, and discussions would be, that funding would be made available for administration in respect of transformation through that.
Okay, so the allocation's nowhere near the 1.5 million that was set out in June, is that what you're saying?
No, but the time taken to bring in any staff, it wouldn't have been near 1.5 million, but it wasn't allocated anyway. So.
Yeah. I suppose that was where we struggled to get our heads around how the pressures would have mounted up to that and how the money would be spent within this financial year. Any other questions, members? No? Okay, thank you so much for coming before us, and appreciate your time and effort.
Chair, just picking up on a point you made, is it possible in the forward work programme we take you up on your suggestion that we invite somebody from the TEO to talk about the structures relating to the protocol, staff structures?
Okay, thank you. Members, just moving on then, just a quick update in terms of our inquiry into gaps in equality legislation. So just to advise that the invitations have now been sent out for the 4th of December, and the clerk has been engaging with the Assembly staff around helping with the facilitation and note-taking. Is there anything else you want to say in relation to that?
It's all underway. We're just waiting for those who can come to wait for replies, basically, and then we'll adjust accordingly if we need more.
Okay.
I can attend now.
Good. So I think I was asking the clerk earlier, and I suppose after the stakeholder event, then it'll give us an opportunity to look at all the responses that have come in. The clerk will then pull together a report, and we'll look to see whether there's any gaps in our own evidence session, and we can decide whether to bring other people back or whether we move forward to discussing any findings, obviously, but probably more important, recommendations. So that's really where we're at. So I think we should probably have this wrapped up then within the early 2025. Did you want to ask or say anything? No. Okay. Okay. So
would that then, once we identify those gaps, or we identify that there are gaps in equality legislation, would that be then for the would it be the committee's intention then to be saying to those areas of responsibility for that legislation to bring it forward, or would it be the committee's intent to bring forward committee legislation?
Well, I think we need to be ambitious as a committee. When the Deputy First Minister was here with the First Minister, I did ask about support for anything we came forward, and they said we would have to see. So I think because it's something that they've been meant to be looking at for years, I would say that we should give them first refusal to take forward the recommendations, and then I would be keen then we as a committee should look at the recommendations for ourselves. So.
But it should very much be on the basis of give them the opportunity for first refusal. However, that needs to be done at pace.
Oh, absolutely. Thank you. Okay, thank you, members. So, draft forward work programme. So, just to seek your agreement then, following last week's decision to delay the process of compelling the institutions in relation to historical institutional abuse, that the committee invite Forest na Gaeilge and the Ulster Scots Agency to committee on the 4th of December to discuss the new identity and languages bodies. We also had the TO officials at that, so that also obviously include them as well. Yeah. Members okay with that? Because we had set that aside for that. Okay. The clerk as well is going to start scheduling outstanding briefings for the new year, but obviously there'll be new ones coming forward, including some that were suggested today. So, given the importance of matters relating to HIA institutions, members may wish to consider holding an inquiry into this matter sometime in the future. With this in mind, I would seek your agreement then at next week's oral session on historical institution abuse for it to be covered by Hansard. Are members content that we would have a proper record of it? Okay, so apart from that, is everyone else content with the forward work programme on page 64? Okay. So correspondence, members, would refer you to page 71 of the pack and page 10 of the table pack for the summary of committee correspondence. I think the only thing in there was in relation to accepting the Speaker's invitation to attend this evening's conferral. I think we're all watching the clock there, it's starting in 3 minutes. But is there any other correspondence anyone would like to discuss? No. Okay, any other business, members? Go ahead, Brian. You had your hands up first.
Okay, well, if I could just say briefly, appreciate time's against us, just regarding the minutes that we did now finally received of your meeting with the First Minister in the morning of our committee meeting, the 23rd of October. To me, when I read these minutes, it does emphasise why we need to have the committee produce its own minutes. I do feel that the tenure of these minutes is very much from the First Minister's point of view and from her officials' point of view.
But can I before you okay, go ahead.
But I just want to make that point because when I read through it, it's a narrative, you know, from the view I feel of the First Minister and her officials. I think it makes the point that there should be, to keep the committee as an instrument of the Assembly separate from the department, you know, and the Minister's office. In any situation like that, it is important that we would have our own minute produced, even though she requested the meeting. I mean, to say that matters were tenuously linked on safeguarding, to try and say, oh, safeguarding is a responsibility of the Department of Health. I mean, we've been through this matter, you know, many times about our role in safeguarding, you know, in historical institution abuse. It's very much people want to see the standards upkept by those who have responsibility for overseeing and these matters and ensuring that there is redress where there were failings by the system and by individuals. So I do take exception to that line in the minute. But anyway, we tried as far as we could and there was not a willingness to answer the questions, even though samples had been provided in advance. So my main point is that in any such situation we should have our own minutes taken on behalf of the committee.
Well, I have to say, just to respond to you, when I read them, they were absolutely bang on. So if Timothy wants to propose that we request separate notes, I think he'll be bitterly disappointed because, as I said, it was a very perfunctory meeting and the minutes, and as you say, it was just flowed. That's exactly how the meeting flowed. So there's, as far as I'm concerned, the notes, scribbles of paper, whatever else anybody else in the room was taking will very much reflect what the minutes were. So no issue.
When it talks about integrity of the office, you know, we have to look after the integrity of this committee.
And that's why we pushed to have the minutes circulated as quickly
anyway,
as
I hope the point is acknowledged that in any such situation in future we will have our own minutes produced.
We discussed that last week. Go ahead, Timothy.
Very much, Chair. I suppose 3 points I want to raise from the minutes. Obviously, it was requested by the First Minister to head off any prospect that the meeting, and I quote, didn't damage the positive work relationship between ministers and the committee. My understanding is that the role of the scrutiny committee is to get to the truth via robust questions, and it's not about preserving a working relationship with the minister. We're here to keep them in check. There was discussion about questions when we were told before there wasn't. So was it clear?
No, don't put words in my mouth. We did not discuss any specifics or any content or anything like that. It was more around the perfunctory nature of questions being asked. So please don't misrepresent that.
I'm not entirely sure that's accurately reflected in the minutes.
Well, then take that up with the private office. I did not. The only element of the questions were the ones that the clerk, as Brian has indicated, that were presented. So that was it. I didn't then go into anything else.
But that was specific questions
that
were submitted.
But you're trying to imply that there was some conversation that took place and it didn't.
I'm not trying to imply anything. All I'm simply saying is there's questions submitted. You said before there was no discussion about questions, but there obviously was, going by the minutes.
Outside the ones that were the 6 that were sent in.
And ones that were talked about in the media. So the chairperson advised the minister that she would limit each speaker to 5 minutes.
Well, if there's 9 people and it's 45 minutes, how else would it be fair for people to...
Who set the time?
I didn't set the time. I was advised that she could allocate 45 minutes.
I hadn't seen that in any of the correspondence, that there would be a time.
Well, I was advised that by the
45
clerk.
minutes.
How else would you think it would be fair? 45 minutes divided by 9. How else would it be fair?
I can understand that, but nowhere in the correspondence have I seen that the First Minister was only available for 45 minutes.
I didn't say.
So going back to the timeline, email was received at 11:06, Michael, and it says in the email that was after correspondence or after a phone call with yourself. Did that happen just directly before that, or was that earlier on in the evening? Was there a length of time between whatever communication you had and the written correspondence?
Directly before. Yeah.
Directly before. Last week we had asked for all the written communication. There's only the email has appeared in the pack. Is it possible to get the rest of the written communication that related to how the meeting was set up? Because there was a number of pieces of communication via email, via text message, and that was requested last week.
There was just the one email.
And then the
The
email
others were phone calls.
all the
and
written
texts.
correspondence that relates to it, which is more than one email.
There was one email that evening, and then that was passed to the chair.
Yeah, in the table we got last week, so there was a number of written communication. It might have been one email, but there's certainly text messages, what was said, and I would certainly request that's put in the pack.
No issue.
Grant. And putting the proposal back to onto the agenda and to the meeting that we seek from the Executive Office, where the newsletters failed in their FOI, all the written notes that were taken during that meeting. And if they don't want to release them to us, we have powers to compel them, and I trust the committee would be serious enough to cite the powers that we have in the letter that we send to them.
That's fine. Carol, go ahead.
Sorry, I'm not picking up what Timothy's proposal is. Is he proposing that because the journalists couldn't get notes for why that we send them on? I'm not really clear. It broke off a wee bit. Sorry, but
See what he is, basically.
We request the notes on behalf of the committee. If they haven't been released via FOI to somebody that's sought them outside of Stormont, outside of the committee, I think there's an onus on this committee, because the meeting dealt exactly with business or directly with business of this committee that we seek them.
No, it didn't. You're trying to imply that we engage in some sort of conspiracy.
No.
Yes, you are.
Chair, if someone
Chair.
hasn't been able to request something from the
Sorry,
FOI,
Chair.
is that not the ICO's responsibility?
Let me just let Carol finish, and then I'll bring you in, Claire, for that question. Go ahead, Carol.
no, Claire's made the point. Our job isn't to do a job for our journalists. If they're not happy with the information, they go to the Information Commissioner. I wouldn't be in favour of that. I think that's just bonkers, to be honest.
Yeah.
My proposal still stands.
Well,
that we request them as the committee.
I think that all you're trying to do is just frustrate this committee.
No, it's not.
There's nothing. When I saw the minutes that were produced, I thought there was bits, and I thought, oh, I forgot that was. Honestly, they were a complete record of what happened that day.
Then there should be no reason.
Well, there
why
isn't
they
any issue, but I think all
release
you're
them.
trying to do is frustrate everything.
Referee.
I'm unclear. Release what? What?
He thinks that there's stuff. He thinks that there's stuff. that
Handwritten
won't let
notes. The newsletter had requested the handwritten notes.
We're
from
not
the
here
private
to do
meeting.
the job of the newsletter.
Oh, I know we're not. But
Well, you are, but the rest of us aren't.
no, but why wouldn't they release them to it? It
I
doesn't
have no
matter who
problem
they
with
came
it.
from.
Have you written to the Executive Office yourself?
Nothing to do with us.
But this is a committee. This meeting that took place was directly linked to this committee, but a witness that was coming here, and I think this committee should ask for the correspondence that they're refusing to release to a member of the public.
We actually don't know that, Chair. The reality of the situation is that if somebody makes a request for freedom of information and they're dissatisfied, there is a very clear and well-established route for them to go down to do that.
Well, then I'm asking, as a member of this committee, on behalf of the committee, I put a proposal that we should ask for.
Okay. Well, I think
Do
that
with us.
I'm not interested in that, because I don't think that there's anything to be gained from this. All you're trying to do is continuously frustrate this committee.
Absolutely not. You being the chair and being involved, I thought you would have been one.
I have no problem with it, but I think that you're just trying to create a false narrative. Every week straight to the newsletter and other outlets
No,
to try and
sorry, no.
undermine this committee.
No, absolutely not.
What? Anyway, what do you think, Emma? Do you want? Us?
No, I'm confused.com. So we got the typed up minutes. So you want somebody's handwritten?
Well, why wouldn't
I've never sent minutes to anybody in my life in my handwritten form. I type them up so that people can read them clearly. So I don't understand.
There'd be no issue requesting.
The chair, I know, but you're at this stage now. You're veering into questioning the integrity of the chair. She said that they reflect the content of the meeting. She said that multiple times, and she was at the meeting. So if you have an allegation or some sort of question as to what the chair has reflected,
simply asking for the public.
Well, you've already been told that there's a route for you to do that. So go down that line.
Well, I'm
do you want to contribute? You were at the meeting with me.
Well, first of all, Chair, just to clarify, the members made a proposal to the committee whether the committee agrees that we're to write for the handwritten notes on.
I propose next business.
What'd you say, sir?
I propose next business.
Okay.
Surely you have to take my proposal first.
Okay. Well, we'll put it to a vote then.
Just before we do that.
Yes, go ahead.
Can I ask the clerk, is it appropriate that we would request an FOI as a statutory committee?
It's just requesting. It's not an FOI. It's just requesting the copy of the notes. I'm not asking for it to be FOI'd. I'm just asking for the committee to directly ask for the handwritten notes from the meeting.
Chair, I believe that would create a very serious chill factor for the note taker, who I assume was a civil servant in those circumstances. I think that is totally and utterly inappropriate. There has to be, as members have said, indeed as Mr. Gasson said, there has to be a level of confidence between the executive office that we have a responsibility to scrutinise and the relationship which we have with them. We have been given in good faith a minute. That minute has been accepted by those who were present at the meeting.
Did you have any issues with the minute?
No, I didn't. They were
so you're
accurate.
calling both of our... Okay. And on the interim permanent secretary, no, you are.
I'm calling what?
You're calling our
honesty,
our integrity into question here.
No, this would never have come up if I didn't read the press article that was released earlier.
Well, I read the minutes via social media before I checked my email inbox, so
I know.
I didn't.
Okay, any thoughts, Sinead? You haven't contributed?
I'm more than satisfied. We've got the minute, and you, Chair, have confirmed the contents of it.
Okay. Okay, so do we want to put it to a vote then?
I'm happy to put it before you.
Okay. So those in favour of writing for the copies of the handwritten notes? 2. Those against? Okay. Okay, thank you. Any other business, members? No. Okay, thanks very much. Thank you.